7.
Seven.
The respondents have filed their affidavit, my lord.
Huh?
The respondents have filed their affidavit. We need to file reply, my lord.
Till at the time.
My lord.
Don't ask for time for filing affidavit.
May
You want an adjournment, take an adjournment, but not on the ground of affidavit.
May it please your lordship. Lordship, in item number 1 and 2, lordship granted liberty on the order dated 13/11, lordship, to file an additional affidavit by respondent number 11, lordship. Due to medical issues, lordship, he could not travel to Guwahati, lordship. So I'm seeking a day's adjournment, lordship. Tomorrow he'll be coming and will be filing the affidavit.
On number 11, I have not asked him to file an affidavit.
Yes, lordship,
I
granted.
have asked the divisional forest officer to file an affidavit.
On 25th, we have filed.
I have not asked I didn't ask the respondent number 11 to file. He has already filed it.
Yes,
I have only said that in view of his filing an affidavit,
lordship.
I have asked the divisional officer to.
May I please? My lord, in this item number 23 and 25, my lord, we are for the petitioner, my lord. Both the petition has become influencers. Matter related to the election and AGM that has already been held. 23 and 25.
And what about 24?
24th, I am not there.
Why is it tagged up together?
No.
You say at the time.
Right.
Because these are all wheat.
May I please, your lord? Consent of the other side, your lordship, I beg to mention item number 70. I'm seeking accommodation for a day, your lordship. In fact, your lordship, I was not well, could not prepare it brief, your lordship. Any
Request of
other?
Mr. S. Botaku, the matter stands adjourned to be listed after 4 weeks.
May it please, your lordship. Lordship 29 for today's list, my lord. This matters, my lord, become in fact of settlement period is over. But
Bora submits that that taking into account that the settlement period is over, nothing further remains in the instant writ petition. And it had become infructuous. Therefore submits that the petitioner is not pressing the instant writ petition, taking into account the above the instant writ. As it has become infructuous, interim orders, if any, stands vacant.
May it please your lordship. Your lordship, item number 40 and 41. Your lordship, the counsel for the petitioner is not well and couldn't appear today. Your lordship, kindly the matter be passed for the day.
Number 40 and 41, at the request of the learned counsel for the petitioner, matters stands adjourned for 4 weeks.
May I please your lordship? I beg to mention item number 15. My senior is on 15.
1550.
15. My senior is on leave. Kindly matter will be adjourned for a week.
15. What is the matter about?
Your lordship, I am not an engaged counsel. I am
Item 12, personal appearance.
Well, the secretary is personally present today, and I have got one instruction. Kindly also pay 139. 139.
Its power is not under 139.
They are reading together. 137 read with 139.
Eh, We are concerned with the second page, the notification of
that is-
12th of March
That is
2000.
silent. That is silent. 12th of March 2002. The
It
power
is
of
for 137.
only 137.
But 137 power is it, can it be given for partition?
Now the instruction says it has to be read along with 139.
How?
Because it says that the state government may empower any.
Understood, but this is not a notification under 139. The power of partition and the union of revenue paying estates is invested with the circle officer, assistant settlement officer under 137. However, 137 can be given for partition. 137 only comes of investing of settlement with special powers. So here what happens? During the settlement period, you are giving certain powers to the settlement officer, which will include all other stuff within the settlement office. But when the power for filing of partition has been categorically only vested upon the
98.
deputy commissioner, shall be presented to the deputy commissioner and shall specify notification. It is for the deputy commissioner to look into all these things. Then under what provision it is happening? This here he may ask other, because the partition is an important aspect. You a partition, a deputy commissioner as per the regulation will also include an additional deputy commissioner. But how a power can be exercised by the circle officer?
But the
What will happen to the appellate jurisdiction? Let us see the appellate jurisdiction.
appellate jurisdiction, it says it to be Board of Revenue.
So are you creating another thing? Can you see? An appellate jurisdiction is appeal shall lie. So are you creating a third trial for partition matters? First, it will be the circle officer, which will be the subdivisional officer. Second, the deputy commissioner. Third, the board of revenue.
The circle officer will exercise power on behalf of the
No, how can that be? How can the circle officer exercise the power on behalf of the deputy commissioner? If you are conferring upon it in terms of 39, the circle officer comes in. So it will be the exercise by the circle officer. And if the circle officer does it, then appeal lies to the deputy commissioner, and from the deputy commissioner it lies to the board of revenue. So are you saying that we are making a three-tier for that? When the act categorically mentions that it is to the deputy commissioner who has to exercise.
and the appellate court's power is also given, it is to be before the board. So
Where?
this is the difficulty. Here, I had somewhere.
Where the appellate court power is?
117 minus. Within 1 year.
An appeal against the decision of the deputy commissioner making a partition shall lie to the board within 1 year from the date of year. Now, how do you amend this? By conferring a power on the circle officer. Well, are you not amending it?
We have not.
Means are you not nullifying it? Because against the partition, an appeal lies to the board. So in view of 117, are you not nullifying the provision of 117 and amending the regulation by investing the power?
That is the difficulty.
Yes, Madam Secretary. First of all, Madam Secretary, I would not have troubled you for your personal appearance had your revenue department provided these notifications and we have requested this notification because one has to take note of this has a lot of ramifications. Once the circle officer exercises such jurisdiction, then an appeal lies to the Deputy Commissioner as per Section 147 and then to the Board of Revenue. That means you are creating 3 tier of proceedings.
Yes, Your
Now-
Honor.
Yes.
So,
Now, however, Section 117 categorically says where the partition proceedings are before the Deputy Commissioner, an appeal lies to the board. So, by investing a power upon the circle officer, you are amending 117, by which 117 has been made nugatory, and also bringing in another tier of, because it will be a case of harassment on the people. How many tiers of litigations they will have? First, they will go to the circle officer, then to the deputy commissioner to the board, and thereafter come. So it will be a non-ending. And also, you have to take note of when this power is being exercised and this power is being given, it will have ramification on Section 54 of the Civil Code of Civil Procedure. Just for example, a preliminary decree is being passed or a final decree is passed in a civil suit, then it will go to the circle officer, where the power is only specifically given only to the DC, isn't it? Section 54.
98.
Not here.
For that.
98 comes here because of 54.
Yes.
So therefore, this will create a lot of problems. Tomorrow, it will have a lot of ramifications in respect to not only it is a case of harassment, there will be 1, 2, 3 tiers where the deputy commissioner is there. Now, deputy commissioner has to do as per additional means the additional deputy commissioner also. So the power should have been given to the additional deputy commissioner, would have exercised that power. So it ends there. Because the partition of a revenue paying estate includes also that the issuance of a patta in his favor. The circle officer, how can he issue a patta? Can he, madam?
Sir, as Your Honor, I have gotten communication from our standing counsel on behalf of the Assam Board of Revenue regarding only to provide the communication that whatever has been issued notification from the government of Assam regarding investing part of partition to the circle officer in time to time and the assistant supplement officer. So whatever is available from our part in the 2002 on 12th of March that has been placed before the honorable court, sir, for by investing power under 137 of the Assam Land Revenue Regulation 1886 and to exercise the power for in the partition cases. Again, in the 2022, sir, 4th of February, the government of Assam is also another issued a power partition cases as Union of Revenue Paying Estate is invested with the circle officer attached who have acquainted proficiency in the survey and settlement training under this section again in the 137 of the Assam Land Revenue Regulation with immediate effect. So the second we are not submitting to the honorable court, sir, and in subsequent time we are submitting it. This is the ground we are already investing the power to them, but the observation by the honorable court will definitely we are taking into note. But in our interpretation, maybe that 137 also says that the power of a deputy commissioner under this regulation within the such limit and with the such restriction and for the such period or survey officer as may think fit. So maybe this could be the
madam,
other way.
the 137 comes into the picture when you have a settlement operation. Now, when a settlement, normally it is the deputy commissioner who has to issue the patta. The deputy commissioner has to make the partition or do whatever may be. He is the highest
Yes.
power. Now, what
Yes.
happens during the settlement officer, that the settlement officer takes over this role And that is how you give it. The power is being conferred under 137 to the settlement officer as well as the other officers while the settlement operation is going on. That is the ambit of 137. But by invoking 139, if you invoke confer a power, 137 you could not have exercised this for giving it to the circle officer. But in invoking 139, if you do that, it will change the entire scenario of the partition proceedings. It will have a long, it will lead to amendment of these provisions which can't be permissible. Because in the entire chapter 6. Now, if you see, just for example, Rule 18. Rule 18 is to be actually issued by the Deputy Commissioner. However, by Rule 3B, the power has been specifically conferred upon the circle officer by way of an amendment. So, unless you amend all other provisions of the chapter 6 of the regulation, including the power which had been given here in 117, 117 has become useless. That is the problem which is being faced.
Your
And
Honor, we
see
are
the-
taking
see
the
the
note of it.
harassment which is going to be caused to the people. And I'm being told what happens. The circle officer makes the area and it is being confirmed by the additional deputy commissioner or the deputy commissioner. Now, how does he confirm if the power has been given to the circle officer? He cannot confirm. He becomes the appellate authority. Yes, Mr. Das, what do you have to say? Yes, this needs to be corrected because it is a case of harassment to the people.
Take into consideration the ramification.
There are a lot of ramifications. They have just made it okay. We'll have more circle officers. So let us give it to the circle officers out there who will do. And the deputy commissioners, okay, we don't touch all these things.
Running from this place to that place.
Ah, because then there is another appeal.
Here in this case itself, people came to deputy commissioner and the court. And the matter will not end.
No. And take about a situation where section 54, a final decree is passed, or a preliminary decree is passed, wherein it says in a suit which goes for another 10 years, that suit is disposed of after 10 years, holding inter alia that this for A is entitled to 50%, B is entitled to 50%. Thereafter, it goes for to the collector, because the word used out there is collector. In section 54, they use the word collector. There's no amendment to the CPC. Now, the collector has been given the power of a deputy commissioner is the collector. Now, under such circumstances, what happens tomorrow? There will be it can't go before the circle officer because the circle officer cannot be deemed to be the collector. Then how do you take care of this? Tell me, with these type of notifications?
But you will have to give it to government. But they have not looked into the other provisions of the law. They have just issued a notification.
Without thinking about it.
Maybe the practical.
I make an observation in an order asking the secretary to file an affidavit as explaining how do they take care of this type of situation. Let us hear from them.
Including 117.
Including 117. How do they take care of this situation? Because this will tomorrow have a lot of ramifications. And I think the government should think about it. Making another avenue for appeal cannot happen. And this power which is being exercised is under 137. How are you getting 139? See the notification.
According to me, my lord, the best way would be, my lord, because of the provision which has appeared before the court. Lordship may direct the government to reconsider the notification and establish the amendment provision, the provisions of the law. But again, filing affidavit, they will be explaining the same thing which they have explained now. I think
No, the only problem why I am saying so, There's a reason why I'm saying so. I can very well say so, that this is wrong. But this list is not before me. There's no challenge to this. So therefore, the question arose while I was taking up the matter that why it should go back again to the circle officer. The matter should therefore go back to the district commissioner, who is, or the ADC, whoever it is, who will take care of it. So the question which arose before this court is the remand which was given by the Board of Revenue, and he has challenged that. I said there was nothing wrong with that. But the question is the remand, if it is made, then it should have been, because he has come against an interim order passed by the circle officer, na?
Order passed by the DC.
By the DC. So against that he has come. Now the matter has been remanded back and the Board of Revenue decided the entire aspect and remanded back matter back to the DC.
Part is not there. If that part would have been there, we wouldn't have filed the appeal at this minor thing. That part is not there of remand.
Demanding is not. He has decided them. No remedy for anybody.
Only if that part was there, we
So
would
it
have
has to be
filed the
partitioned.
writ petition.
And has to be punished.
But I think this needs to be corrected.
Yeah.
Because tomorrow people are harassed and you don't every time get hold of these type of cases. So let me just put my thoughts out here and ask them to file an affidavit. And with that affidavit, I can pass directions. Then I take it up with me.
They have given the responsibility to circle officer. Practically, because circle officer in large numbers, DC is a small office only.
DC includes the ADC.
Deputy commissioner, yes, he can.
DC includes the ADC. So therefore the ADC will do it. They can do it. But it has to be done by them. Yes, you can seek for a report from the circle officer and then do the partition. That is another aspect. But you cannot, circle officer cannot pass that order
Appeal has to go from the ADC or DC.
to the Board of Revenue. That is what.
My lord, the revenue board is, this revenue department is not a party in the present proceeding. One aspect. So asking the secretary to file an affidavit would be difficult.
দেখো, pursuant to the order passed by this court on 19/11/2024, Srimati so-and-so, the secretary, Revenue Department of the Government of Assam is present. Mr. A. Bhattacharya, the learned standing counsel of the Revenue Department, have also produced a notification dated 12th of March 2002, on the basis of which power of partition and the union of revenue paying estate have been invested with the circle officer / the assistant settlement officer under section 137 of the Assam Land and Revenue Regulation 1886. This notification have been placed before this court along with an instruction which is kept on record and marked with the letter X. The issue as to whether the circle officer can exercise the powers as specifically conferred upon the deputy commissioner under Chapter 6 of the Assam Land and Revenue Regulation is a case of vital importance, taking into account the ramification it has on the people. A perusal of the various provisions of Chapter 6 of the regulation would show that the application seeking perfect partition or imperfect partition, application for the perfect partition is to be presented to the Deputy Commissioner. It is further seen that it is the Deputy Commissioner who would decide the said partition proceedings. Further to that, in section 117 of the regulation, it has been also stipulated that an appeal lies against the decision of the Deputy Commissioner making a partition to the board within 1 year from the date of which the partition takes place. This court have also taken note of the provisions of section 147 of the regulation, whereby an appeal whereby the appellate forums have been duly mentioned. In terms with section 147B, an appeal lies to the Deputy Commissioner from any order passed by the subdivisional officer, assistant commissioner, or extra assistant commissioner. The subdivision officer would come within the ambit of a circle officer. From the order of the Deputy Commissioner, an appeal lies under section 147A of the regulation to the board, Assam Board of Revenue. This court have also taken note of section 137 of the regulation. A perusal of the said provision shows that the state government has the power to invest the circle officer, settlement officer, survey officer, assistant settlement officer, or assistant survey officer with all or any of the powers of the Deputy Commissioner under the regulation within such limits and with such restrictions and for such period or survey officer as they think fit.
One 137B, my friend. 137B.
137.
There is a note B.
In addition to that, it is also seen from a note appended to section 137 that that all Mozaddars in the Assam Valley district, and in the case of Mozaddars who are minors, their sort of Bharakars, SARBARAHKARs, have been appointed as assistant settlement officers and have been invested with the powers to effect registration under Section 53A in uncontested cases, as well as to dispose of under Chapter 6 of the regulation all applications for partition of revenue paying estates in which no objection is preferred. From the above, therefore, it would be seen that the power which has been invested as per the note as assistant settlement officer is only to be exercised when there is no objection. There is a provision how the settlement operation starts, no?
Part B,
Hmm?
part 33, my lord.
No,
Regulation.
no. The government, how it starts and ends. Yeah. No, the government has to notify. There's one provision, no? The government has to notify that the settlement operation have started. And also has to close it. Is it the provision?
17, start from 17.
Hmm?
18,
18,
18,
80.
18.
Ah. And how does it close? There's also another chapter, it has to close. A reading of the provisions of section chapter 3 of the regulations would show as to how a settlement operation would be initiated. There's also another here, as well as shall culminate.
Perhaps 90.
Huh?
90.
No, this is annulment. This is not annulment. Annulment, we are not concerned. There's a closer anyway. Take it. To culminate. It is the privacy opinion of this court that section 137 would only come into operation during the settlement period. However, be that as it may, the question arises as to whether the issuance of this notification dated 12th of March 2002 and made applicable during the period when there is no settlement operation would impact the provisions of chapter 6 of the regulations, wherein it is the specifically the deputy commissioner have been empowered to make the empowered to decide the partition proceedings. Under such circumstances, this court therefore directs the principal secretary to the government of Assam Revenue Department to file an affidavit explaining the said aspect. It is, however, noticed next. It is also noticed that during the hearing of the proceedings, that the Revenue Department is not a party to the instant proceedings. Accordingly, and the presence of the Revenue Department is necessary, taking into account the issue so involved. Accordingly, this court impledes the Commissioner and Secretary, Principal Secretary to the Government of Assam Revenue Department as the having his office at Dispur, Guwahati 781006 in the district of Kamrup Metro, Assam, as the respondent number 5 to the petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and on the basis thereof, the registrar of the court shall make necessary changes to the cause title, as well as also update the same in the CIS. List this matter again on 17th of December 2024. In the meantime, the affidavit be filed by the principal secretary as directed herein above.
Right. Dispense. Presence. Dispense.
Oh, the personal appearance of the secretary is dispensed.
Right.
Give her the name, huh?
Gitanjali Bhattacharya. Bhattacharya.
Bail hearing BA, item 70.
Yes, sir, on last occasion, your lordship was pleased to call for uh, status report, up to date status report from the trial court. But as per office note, it appears that the status report is not received. Office note dated 26/11.
In fact, Lordship, two witnesses are examined till date, and those two witnesses I have enclosed in my petition also. Lordship.
That is on record. Yes, only.
Your name?
Yeah, wait.
You are the counsel for the other one who got the bail.
Yes.
How many witnesses are left?
Here, in fact, if your lordship says that in the charge sheet, 4 witnesses are mentioned, 2 witnesses are examined, and out of them, lordship, one is cited in the charge sheet and another was not cited in the charge sheet. So altogether, 3 witnesses still left, lordship. Lordship, may I kindly see page I'm referring to. Page 24, lordship.
As per the charge sheet, these Yaba tablets were found in your possession.
So there is, as per FI, it is there.
As per FI and charge sheet, it was found in your possession.
Lordship. But if your lordship see the evidence of these 2 witnesses, they said another lady was there. And surprisingly, police have not made any whisper about that witness, about that person, lordship.
But Mr. Counsel, isn't it the law that when I am passing an order granting you a bail, I have to be prima facie satisfied that you have not committed the offense?
Section 37 says, lordship, that there should be reasonable ground for believing that he is not guilty. So if that is so, lordship, may I kindly see the prosecution case and what the witnesses said. If
But
it
the
appears-
prosecution case, it was found in your possession.
No, lordship, may I kindly turn to page 20.
Of?
Page of my petition. Lordship.
I mean, how many days you have inside?
I am 3 years in custody, and lordship, I am citing on the judgment of Honorable Apex Court, which says, lordship, delay in trial will dilute the rigors of section 37, lordship.
What?
That if there is delay in trial,
You want to
then-
show a judgment
lordship,
of
on
the
the
Supreme Court?
Honorable Apex Court. That-
Yes. Let me dismiss it, go to Supreme Court. Tell me, what is it? Why the other prosecution witness have not been examined?
That could not be, that is not reflected in the record, my lord. I tried to find it out.
Huh?
That is not reflected in the record, my lord.
He has been in custody from when?
See, lordship, that 3 years, 3 months, 1 day, lordship, as on today.
3 years, 3 months, what? How much time it will take?
Only they have examined only 1 witness, lordship, from the charge sheet. From 4 cited witnesses, they have examined 1 only.
Why
It's
you are
in
not
3 years.
so? Because of your carelessness, this has happened. When I passed the judgment, at that time, charge sheet had already been delivered, didn't it?
Lordship.
I had taken note of the judgment on 27/9/2022. Yeah? We have it on Friday. Give me a timeline when we are completing.
Sorry, my lord.
I'm having it on Friday. Give me a timeline within what time you are going to complete. Your witness. Don't give me a timeline, then obviously 21 comes. Article 20. Isn't that the
Lordship.
judgment?
thing is that not case is being conducted by somebody else, there, trial court.
Are you not the PP or additional PP?
I'm here recently, High Court.
So are you not in a position to inquire with your investigating officer and find out? Or whoever the trial officer,
I can talk
the
to
person who is there. There's a person out there now who takes care of all the cases out there. Every investigating agency has that. When are they going to do it? If you come up with this thing that no, nothing doing, we don't know when it is being completed, then obviously that's the judgment of Justice Bhuya.
Justice Bhuya is also there and one Ravi Prakash is also there.
Huh?
One Ravi Prakash, no, Ravi Prakash.
And he becomes a Supreme Court judge.
No, not judge, Lordship. That's
Then?
Honorable Justice Suryakant and Honorable Justice Dipankar Datta, Lordship.
Friday. Give me a tentative timeline. In what time you are going to complete your and I give them the dismiss this liberty to again refile after completion of that day. After that day, on the first day itself, he gets the pay. Personal liberty is the question. If we don't see the end of the tunnel, obviously, it has to be. And he has got hold of a judge out here who is a bit liberal on granting leave. Because of the Supreme Court judgment, I am now here. This matter again on 29/11/2024, on which state Mr. So-and-so, the learned PP, shall give a positive timeline within which the evidence of the prosecution with
Item 1 and 2 for admission.
the affidavit has been filed. It's the
Ranjit Kaur has filed his affidavit on 25th, 11 May.
So respond number 11 was asked to file an affidavit to the effect why proceedings under before the register of newspapers of India should not be.
Lordship, it has been, Lordship, but due to his Lordship, he could not travel, so he'll be coming tomorrow, Lordship.
No, you submit. What are the guidelines?
D dash is out of station, my lord.
Huh?
So D dash, my lord, is out of station.
Out of station. Your problem has been solved, so you're not bothered.
But appearing, my lord.
You're not bothered. The problem has been solved. And why should this court further proceed? What does the DFO say?
So says no call has been made. He used 2 mobile number. No call has come to requesting him. Because even they cannot make a call to DFO. It is the publicity officer we have contact with the paper. If any call they requested, have to go to the public relation officer. Because DFO have no connection with the paper. Even he doesn't know where which paper it will come.
But Mr. Bora, now, you see, you have till now not gone for E option.
Now it has E-action. Now it is E-action.
This time,
This time it is E-action.
But then I don't think there's a requirement of anything. Now you are following E option. So
All
then
paper
I don't
publications
think
are
nothing
E-action done, my lord.
is there. But don't you think one of them is making a false statement? I think let the Registrar General file a complaint against both. That is the best way. There has to be somebody making a false statement. You say that you did not know.
No call has been made to, because at that time, at point of time when.
Whereas he categorically says that he has been
Made a
informed. The
So-
statements being made. Somebody has to be put to the dock, taking into account that there is a false statement made before the court. Now e-auction is there, so the question of guidelines does not happen.
And the call should have been made between 8:30 and 9, because they say after 8:30, they came to know that there is no space. That had to be called, and there I have given the two number also, which is the DFO uses. He says no call has been made, because I cannot be contacted, madam, because he is not I am not the person who is asking him to publish. It is the public relation which is I am not in the I'm not aware regarding publication. Publication is the publication, the publication chief head of department of the publication. Nobody will contact me saying that I can defer, and I cannot defer even if a request comes, I cannot defer it, because it is the public relation which has given the letter to publish it. This is the ball is out of his hand.
So as per the RNI Act, isn't the investigation required? Because they are making certain false statements. Because this will lead to cancellation of their license. I think these type of newspapers should be shut down.
We have asked them to not to publish anything in the newspaper, because this was the biggest newspaper circulation. Now,
No, this type of
now
newspaper has to be shut down forever. This is no freedom of 1918 does not come when they made false statement. Because on oath they have made false statement. And that person who came out here, he doesn't know head or tail.
that's why
He doesn't know.
he doesn't know. He doesn't know even who is controlling the paper and how these things are
No.
going on.
So that person, if it is the concern, I think this is a high time, because what happens in a newspaper, you have the names of 3 persons down. There might be a newspaper. You have the copy of the newspaper. I'll give it to me. The entire one. Yes. No. Turn the last page down below.
Down below. Yes, there is a after that.
Who are the people who are there?
Yes.
Read it.
There's the owner, printer, publisher, so and so. All the names are there.
Who are the owners? Printer and publisher, all are responsible.
Owner, printer, and publisher by Garg What Basumatari from so and so.
What is his name?
Garg KRKHWDAU. Garg Khodo Basumatari.
So he is not the person who has come.
Owner, public. He is not the person who has come.
So why is the response number 11 filing it? He himself says he doesn't know anything.
Some Rupson Brahmo.
That person has no business. He doesn't know anything.
Doesn't know anything.
Madam, you file your affidavit through these people who are responsible as per the RNI. Not that person concerned. I'm making it very clear. Not that person concerned. These are the people who are actually responsible as per the RNI Act.
Garg Khodo Basumatari.
You see, that person is only responsible for 340 proceedings. But here, these are the people who are responsible for under the RNI. Can't file an affidavit by anybody else. Because my affidavit is only to the effect that why I should not refer the matter to the RNI for an investigation to be carried out against him. So the affidavit has to be filed by these people, because these people are actually responsible, not that manager. His name is there in the, no?
No, manager's name is not
there.
there. Not there.
pursuant to the order passed by this court, that affidavit may not have come. That affidavit has not come. Now you have again published in the newspaper, in spite of having an e-auction. This time, you are going for an e-auction,
E-auction.
then why are you publishing? Is it required? Oh, there also you are required to
That is
publish.
required. We have now published in three big newspapers.
So now you have done it in Sentinel, Niamia Barta, and very good.
And both the all petitioners are the highest bidder as per my instruction.
Oh,
Petitioners are the highest bidder.
therefore we don't see you. The senior does not appear.
My senior today is out of station.
Huh?
He is appearing. My senior is appearing, but today he's out of station.
Anyways. Mr. Espora, the learned counsel appearing on behalf of the BTC submits an affidavit has been filed by Sri Ranjit Kaur, who was then the DFO of the Parbot Jora Division, Suparighat, BTC. And on 25/11/2024, said affidavit is not on record. In addition to that, the learned counsel appearing on behalf of the respondent number 11 submits that the affidavit, as was required to be filed in terms with paragraph 4 of the order dated 13/11/2024, could not be filed. So prepared. The learned counsel therefore submits that some time may be given in that regard. This court makes it clear that taking into account the observations made in paragraph 4 of the order dated 13/11/2024, whereby this court had asked the respondent number 11 to explain as to why directions should not be issued for appropriate investigation by the Register of Newspapers for India in respect to the working of the said newspaper. The affidavit has to be filed by either the printer, owner, printer or publisher whose name is reflected in the newspaper. List this matter again on 16th of December 2024.
Item 3.
May I plead the lordship, my lord, in terms of your lordship last order dated 12/9/2024, my lord, a new committee has been constituted, my lord, but it has not concluded its report, my lord. So some time is required, my lord. There are the preliminary inquiries.
Deborah, appearing on behalf of the Health Department of the Government of Assam, submits that a new committee has been constituted pursuant to the order dated 12/9/2024 on 6/11/2024. The office order has been placed before this court, which is kept on record and marked with the head. The learned counsel therefore submits that some time may be granted for the new committee to submit the report. To establish this matter again on 22nd of January 2024. The committee is directed to place before this court the report.
Objection.
Item 4.
Done.
The assessment has been done and the PWD has sent the reassessment detail to the ADC, the column. 6/11.
So this is done at 4,25,000.
No, total is, he had some, Kacha house, total is 14 lakhs. The
Huh?
last page. RCC construction, that's house,
Oh, many places.
total six.
Huh?
Total six.
Hotel.
First one, Lordship will find. First is construction of Assam type house, GCI seat. That is 4 lakhs. Next is Lord, construction of Assam type house, GCI, that
So
is,
now this assessment has been done
reassessment has been done as per the order of the appellate,
as per the
appellate order.
award. Who is going to pay?
The NHAI,
It is sent Kala. Kala will send to us.
Lordship.
Kala is 1 lakh.
No, forget about these, all this via media business and all, will send or not. You are there. Who is going to pay? The award has been passed, the reassessment was directed to be made. It is your duty, you are a part of that proceedings. It is only because of the reassessment being not done, he has not got the money. Now the reassessment has already been done. Now under such something you are required to pay. I'm not concerned how, whether it's, no.
Kala has sent to us.
Why should it Kala? You give a copy to him, enough. When you are paying. When you are paying now, it is an award along with interest. It has to incur interest. This is the amount which he has to pay. He has to pay the compensation as per the new act. So the amount will incur interest. Isn't there interest?
It's to Kala has sent to us. Okay. This to from Kala. Kala has to send to us.
Are you saying that the National Highway Authority of India doesn't come within the jurisdiction of the court? Then, when Mr. Borua, kindly appreciate one thing. Don't come up with all these things. Here is the person who should have got this money as on the award was passed in 2014. 10 years down the line, now you are going into all these things. We are not concerned with all these things. Whether the Kala sends it, the Kala sends it or not, you were a party to that proceedings. There was an arbitration award. And in terms of the arbitration, there was a reassessment being done. The reassessment being not done, he has filed a writ petition. Now this reassessment has been done, you are to therefore pay. A copy of this will be given to you to take it up with the authorities. We come back again on 18th of December, we'll see whether payment has been made. But somebody said, according to this court, impedes the commissioner PWD
Yes,
for making the reassessment. That's
reassessment, that has been done.
all. Pursuant to the order dated 11/11/2024, whereby this court had specifically directed the respondent number 6 to consult the authorities of the National Highway Authority of India and make assessment in terms with the award dated 19/4/2014 passed in RR case number 23/2012. Mr. D. Nath, the learned counsel, appearing on behalf of the PWD building division, submits, appearing on behalf of the newly impleaded respondent number 6, submits that the reassessment have been accordingly carried out. In terms with that, the learned counsel therefore have placed before this court the reassessment which was done on 6/11/2024 and sent to the additional district commissioner Kamrup. The same is kept on record and marked with the letter Y, letter X. This court have duly taken note of that pursuant to the said reassessment, the National Highway Authority of India is bound to make the said payment inasmuch as there was no challenge to the said award under any provision. There was no challenge to the said award passed on 19/4/2014. Pusto. This court further, having taken into account the recent judgment of the Supreme Court in the case of Ultratech Cement versus Mastram, reported in 2024 SCC Online 2589, wherein it has been categorically observed that once the determination of compensation is made, it is the bounden duty of the authority to make the payment immediately. Directs the National Highway Authority of India to release the such said payments, to deposit the said payment before the additional district commissioner Kamrup Mingaon within 15 days from today, along with the applicable interest. Pusto. Upon receipt of the said amount, the additional district commissioner, who is the competent authority, shall release the payment, disburse the payment to the petitioner. List this matter again on 8th of January 2024 for an update. A copy of the said assessment proceeding report which has been kept with and on record and marked with the letter X have been provided by Mr. Dina, the standing counsel of the respondent number 6, to Mr. C. Burwa, the standing counsel of the National Highway Authority of India, to do that.
Item 5.
Yes, what is this? Mr. Bhattakur, what is this?
Basically, we are contending that a loan agreement was made between the petitioner and the apex bank to recover balance dues of an earlier loan. So now, Lordship, the terms were changed, and based on that, there was a principal. The earlier interest and the principal was merged as a single principal amount, and then a new interest rate of 10% was imposed on a period of 5 years. So in the agreement, an amount was also specified, 22 lakhs as the total interest amount. In our affidavit, Lordship, we are saying that even though that amount is written, but that is a miscalculation. That amount is there in the agreement, Lordship, there's no doubt. But as per our affidavit, that is not the correct calculation of 10% interest.
Where is that letter, the impugned letter?
That is Directive 6, Lordship. Directive 6, page 55. This was issued subsequently when we informed.
Oh, so you are asking for any additional 10%, the total 81 lakhs. Out of there, they say that it was wrongly mentioned as 22 lakhs.
In this respect, Lordship, there was an agreement sanction letter.
Mr. Todi, are you filing any reply to the affidavit?
No, Lordship.
You don't want to? You take the risk?
They have otherwise admitted the facts about the agreement and the sanction letters.
Pending dues of so and so
Only the
was settled by the
calculation
bank at rupees so and so. But an agreement between one was executed between settled amount of the bank.
Two letters, Lordship, was issued after we had completed all the
Show me
installments.
the agreement,
Lordship may come to Annexure 2,
page.
page 41. This is the sanction letter issued by the respondent bank, Lordship. They have converted the specialty term loan and
The interest at the rate of 10% simple per annum to be accrued from the second year onwards and parked in the interest-free account of so and so.
And
for
amount
rupees
has been
per month,
specified, Lord.
12 lakhs. Only will have to be deposited in 4 equal quarter of rupees 36. So this is the interest.
interest they have calculated, Lordship. Para 5 is the principal amount. Also, they have
Shall
divided.
accept the advance payment of the entire year. So this is your offer.
Yes, Lordship. This is a sanction letter.
This is the sanction.
Sanction letter.
And you
Lordship
have to
may come
accept the
page
sanction.
42. Page 42, they have given the entire table of the calculation of the EMIs.
Okay,
which
if
we
the
have paid
above
by
terms
both
are
the-
here. That is what, Mr. Todi, most important is page 43. If the above terms and conditions are acceptable to you, please furnish a letter of acceptance along with the resolution of the board's resolution here. So thereafter you agreed.
We
Isn't
agreed
it?
and then agreement was executed.
Then it's okay.
Lordship.
So now on that basis, this has been done.
Done.
Now how can you do? This is your offer.
And the agreement was also executed, Lordship, Annexure 3.
This is your offer. That is why I said. Where is that particular document? This particular says that this is it. Wrongly, rightly. Where did you change it prior to making clearance of anything? You should have come up with an addendum or whatever, maybe make some corrections to the agreement. But the agreement remains as it is. The offer which was given, the proposal, he has submitted a proposal, you have given him an offer of 22 lakhs. Page 42 categorically shows the interest at 22 lakhs per year and how you worked out. You may have done it for whatever consideration, rightly, wrongly. Take it out from all this here. But you can't.
Only thing is, Lordship, if this 3 crores 15 lakhs, that is treated as the principal amount. And if 3 crore 15 lakhs, Lordship, is treated as the principal amount and 10% simple interest per year for a total term of 5 years. Then, Lordship, this 22 lakhs is very low.
You can't help it. This is your offer.
That is what has been accepted as a miscalculation. That is it, Lordship. That is-
Understood. But can you later on say? Or is it anyway saying that the words will take effect from the letters? Or the whatever is written will take effect in respect of the words? Like in a bank check, if you make some mistake in the number, the words, what you write would take effect. Isn't
It is a peculiar case, Lordship, that I accept. But
No, peculiar case. There are many cases, you mostly file it in the civil courts. This is your offer. The problem arises because this is what you say. If it was a sanction letter purely that we have sanctioned, yes, there might be a mistake. You give this offer and say that, look here, if you accept these terms, kindly sign here. And accordingly, he signed it. Yes. Now, how can you resile if it be a breach of a contract?
there is a fiction in the document itself, because it says 10%. At the same time,
See,
they
the
have
language is also not so clear. Kindly see number 4. The interest at 10% simple interest per annum to be accrued from the second year onwards and parked in the interest-free account of so-and-so, 4 rupees so-and-so. Only will have to be deposited in so-and-so. So this is how you have made it. You made it a more complete, simple language. I think Mr. Bottako didn't pass out law at that time. Isn't it? This is why Apex Bank is that Mr. Bottako said.
that is the only stand the bank has got as per the affidavit.
So we have to issue, set aside those letters and issue directions for making payment.
For
Releasing
release
of the,
mortgage book.
releasing of the original. Let's start to dictate. Heard Mr. A to D, the learned counsel appearing on behalf
Dr.
Dr. A to D, the learned counsel appearing on behalf of the petitioner. And Mr. I Botaku, the learned standing counsel of the apex courts.
Lordship, can it be on behalf of Mr. P.N. Goswami?
Absolutely no. Where is he?
Officially, Lordship, I am not the counsel for the bank.
Then we should repass none appears. How can it be on behalf of? He is not there, can't help it. You have to appear. The PM was I Botaku appears. Mr. I Botaku and Mr. I Botaku, the learned counsel appearing on behalf of the respondent 2 and 3. Because he submits that he belongs to the same office. He submits that he is associated with Mr. P.N. Goswami, the standing counsel who have entrusted him to do the instant writ petition, to appear on behalf of the respondent 2 and 3. I come back in 2 minutes. Upon the respondent numbers 2 and 3 to release the original title deeds and documents of the petitioner, and also to issue the no due certificate in favor of the petitioner with regard to the STTL loan account. From the perusal of the materials on record, it transpires that the petitioner, who is the owner of a tea factory, had availed loans from the respondent number 2 by deposit of original title deeds, mortgage and hypothecation of all properties, that is lands, buildings, machineries, sheds, structures and fixtures, and processed tea of its tea factory as per the deed of mortgage dated 27/11/1998, executed in favor of the respondent number 2. In view of the fact that the petitioner failed to make payment of its dues in time, the account of the petitioner was made a non-performing asset. The petitioner was offered to settle the dues of the loan amount by way of a specialty term loan (STTL) for repayment in installments as per the Indian Bank Association (IBA) Tea Revival Package. This offer was made on the basis of a communication dated 30/6/2008. Clause 4 of the said letter, being relevant, is reproduced hereunder. It is further seen that in the said letter, the manner in which the deposit of the quarterly installments were to be paid have also been mentioned. The interest which was required to be paid was rupees 22.12 lakhs in 4 installments on 30/9/2015, 31/12/2015, 31/3/2016, and 36/2016 of an amount of rupees 5.53 lakhs each, totaling to rupees 22.12 lakhs. Further to that, it was also mentioned in the said letter dated 36/2008 that if the terms and conditions were acceptable to the petitioner was required to furnish a letter of acceptance along with the resolution of the board of directors of the company for necessary action. The petitioner duly accepted the same as would appear from the records, and thereupon an agreement was entered into on 15/7/2008 by and between the petitioner and the respondent number 2. Clause 2.2 of the said agreement being relevant, is reproduced hereunder. Isn't that the clause? Clause 2.2.
And before it clause F also, you can consider. Here also the amount was defined.
Clause. The recitals contained in the said agreement, more particularly at clause F, and further, and the terms so agreed, mentioned in clause 2.2, being relevant, are reproduced hereunder. Page 48 of Pabo and page 49 of Pabo. Huh? The record further reveals that the petitioner duly paid in terms with the offer made on 36/2008, as well as the agreement which was entered into on 15/7/2008. And thereupon requested the respondent authorities to return the original mortgage documents and also the no due certificate. The respondent number 2 and 3, respondent number 3 issued a communication on 31/5/2017 to the petitioner that while issuance of the communication dated 36/2016, 15, 36/2008, as well as in the agreement entered into on 15/7/2008, there were certain arithmetical mistakes in calculation of the interest. It was mentioned that the interest which ought to have been paid was rupees 81,23,400 and not 22,12,000 as mentioned in the communication dated 30/6/2008 as well as in the agreement dated 15/7/2008. The respondent number, the managing director of the respondent number 2 further admitted receipt of the amount of rupees 22,12,000. However, directed the petitioner to deposit a further amount of rupees 59,11,400 in order to get the release of the original title deeds. Subsequent thereto, another communication was issued by the general manager in charge of the respondent number 2 on 27/7/2017. Being aggrieved by these communications dated 31/5/2017 and 27/7/2017, the petitioner has therefore approached this court by filing the instant writ petition. Pursuant to the filing of the instant writ petition, this court, by an order dated 6/9/2018, issued notice. An affidavit has been filed by the respondent bank reiterating its contentions on the basis of the communication dated 31/5/2017 as well as 27/7/2017 to the effect that there was a mistake in making the calculation of the interest which ought to have been rupees 81,23,400 and not 22,12,000. This court, on the basis of the above pleadings, this court have heard the learned counsels appearing on behalf of the petitioner as well as the counsel appearing on behalf of the respondent. From a perusal of the materials on record, it is seen that the respondent number 2 have given a the respondent number 2 had given an offer for conversion to STTL facility of dues payable by the petitioner. In the said communication dated 30/6/2008, it was categorically mentioned that the interest which was to be payable was rupees 22,12,000. And there was also 12,000. And the chart so mentioned in the internal page 2 of the communication dated 30/6/2008 also mentioned how the payment was required to be made. In addition to that, upon issuance of in the said communication, it was also mentioned that the petitioner was required to accept the said offer so made by the respondent number 2 bank. The petitioner duly accepted the said offer, and in pursuance to that, on 15/7/2008, an agreement was entered into containing the similar conditions which have been mentioned in the communication dated 30/6/2008. From the above, therefore, it would be seen that the respondent bank never took any steps for making any correction during the pendency of the said during the period so mentioned in the communication date, during the period when the said amount was to be repaid by the petitioner to the respondent number 2 bank. It is only after the entire amount having been liquidated and the petitioner requested for the original documents on 22/4/2017, that the respondent number 2 have made the demand, additional demand of rupees 59 lakhs 11,400. Pusto. The said aspect categorically shows, Pusto. In the opinion of this court, the said demand of rupees 59 lakhs 11,400 made on 31/5/2017 and subsequently followed on 27/7/2017 in the is on the face of it contrary to the stipulations of the offer so given by the respondent number 2 to the petitioner, which was duly accepted, as well as also contrary to the agreement which was entered into on 15/7/2008. This court at this stage further finds it relevant to mention that respondent number 2 is a state within the meaning of Article 12 of the Constitution. And under such circumstances, it is bound to act fairly. And it is bound to act fairly and reasonably. The action on the part of the respondent number 2 to further demand an amount of rupees 59 lakhs 11,400 not only is contrary to the provision, contrary to the communication dated 30/6/2008 as well as the agreement dated 15/7/2008, but also shows that the respondent number 2 have acted unreasonably, unfairly, as well as arbitrarily. Accordingly, this court therefore sets aside the communication dated 31/5/2017 as well as the subsequent communication dated 27/7/2017 and further directs the respondent number 2 and 3 to hand over the original mortgage documents which were submitted by the petitioner to the respondent number 2 at the time of creation of the mortgage, and also issue a no due certificate in respect to the STTL facility so availed by the petitioner. The same be done within 15 days from the date a certified copy of this order is served upon the respondent number 3.
But the impugned communication is also 24/5/2018. There are 3 impugned communications.
What is that?
It's also a letter, final letter also. Final letter issued rejecting our claim.
As well as এইটো এখনো ভৰাই দিব
24/5/2018.
ওপৰতো লগাই দিব। These are all subsequent letters. And 24/5/2018.
Much of.
Yes, this matter was lying so for such a long time.
Step 6.
Orang. What is this?
Lordship, last order, Lordship, I was directed to obtain some instructions.
Who was the officer? Yes, madam, what is your case?
The petitioners are evicted from their land. The dog number and patta numbers are in page number 14 in our pleading in para 5, Lordship. The respond number
Of
7,
their patta land. What is your patta number?
Lordship, patta number 49,
Huh?
land patta number
49?
and patta number 37, 34, 55 and 78.
Hey, all petitioners are coming together. Who is paying for response number 7?
The affidavit may not, could not be filed. Respond number 7 is very, he is frequently hospitalized. I've taken the inspection. Well, what has happened in this case?
Is he ill from 2019?
That is the instruction. The affidavit was prepared and sent to him, but he's
So
an aged
since
person,
2019, he's 5 years.
I can only argue from the whatever is there in the material on record. Well, three aspects of the matter are there. First, your lord, as far as the aim of the petitioners are concerned, they are saying that they have been disposed from the patta land. You know, the notice that they have themselves admitted to have in respect of the government. Fact number 198. In fact, not once, but two notices were sent to him. One is 22/2/2018 and the other is 7/3/2018, which they have annexed with the petition. Another point is that the petitioners have not whispered in their petition any date, the date of disposition. They only mentioned about the notice.
Huh?
There is no whisper in the petition as to on which date.
Madam, you tell me one thing. This is a kacha patta. Kacha patta, do you know when it happens?
Yes, Lordship.
When is a kacha patta issued? Let us also be knowledgeable from your insight.
But Lordship, our patta is a periodic harass patta land.
Eh.
In page number 8, Lordship, we have mentioned in our pleading that the father of the petitioner number 1, 2 and 3, namely late Putturang, got periodic harass patta number
Annexure
14.
A is a kesa patta.
Yes, Lordship.
This is a patta number 34 in respect to some dag number. Okay. You are not concerned. Where is your periodic patta?
Annexure,
Periodic patta.
annexure B, look.
This is periodic patta, annexure B. The number 42, 49.
Yes, 49, Lordship.
The number 49, it has dag number 201,
40,
240, 260, 272. Now, have you been evicted from this area?
Yes, Lordship. Lordship, kindly come to the affidavit in operation filed by the respond number 6, Lordship, which is filed on 29/4/2019. Yes. Respond number 5.
Respond number?
5, Lordship.
What does it say?
Lordship, in this affidavit in operation, Lordship, in para number 5, he admitted that he evicted the petitioners from their disputed land, Lordship, and he has not disputed the para number 5 of our pleading. And the name of the circle officer is also mentioned in para number 5.
Respond number 5, you know that SP, this was, and Lordship kind of goes to the paragraph, affidavit filed by respond number 4, Lordship.
And Lordship, the whole eviction process is done by the respond number 4 with the help of the respond number 6, Lordship.
So you say that it is in dark number 198. That's your case. Not in their land. But the petitioners have their own land.
Well, that Lordship, my lord, instruction law kindly see the person, the name of the persons who are mentioned in the my lord, that instruction. The 159 and the old dog number 159 and 260 Lordship. 174 new dog number. One
Of which
quarter seven
patta?
less is recorded as a government.
No, which patta?
Lordship, it did patta, they have not mentioned here.
Eh?
Only dog number has been given.
So that number is the government. Are you saying that? And there you are mentioning Patta
No,
da
my lord,
Opal Tanti.
Those are the government land. From that area, my lord, the eviction was carried out. And the patta land, those who are, my lord, they have the person, the private land, well, that was not been done.
You produce the trace map of these tag numbers of old Patta number of this Patta number. Well, let us not go by the Kacha Patta. Periodic Patta number. This is your land.
Yes, Lordship.
Produce the trace map.
Lordship.
And where is the dark number 190?
Lordship, kindly see the
Oh, Mr. We are concerned with whether he has been thrown out of their land. First, the respondent number 5 files an affidavit wherein he doesn't say anything. He says that on the basis of a complaint being given by respondent number 7, I have done it. Which means they have taken action without following the due process. Because if they are doing on the basis of a complaint made by them, the circle officer or anybody has no business to take these people out. The petitioner specific case says this is the land which belongs to the petitioner. This is the Kiraji Patta, and I have been evicted. We have been evicted from this land by the circle officer at the request of the respondents. And this is also being said by the respondent number 5 in his affidavit.
respondent number 5, there is superintendent of police, my lord, teacher.
Wherever it is.
In the respondent number 4, those who are-
Respondent number 4 also doesn't make it very clear. Where is the land of this petitioner? Produce the trace map, we'll
this-
find it out.
the
No.
eviction was carried out only for about 198.
Because this person concerned and ask him to file an affidavit. This person, Sabyasashi Kashyap, where is he? Is he the person who filed the affidavit? No, some other Tomoy Bora.
He has been,
He
that
didn't
part
do
of-
it. Ask him, who is the revenue secretary? He's the revenue secretary.
No, my lord, he is, now my lord, he is the
Urban
deputy
Affairs.
secretary, Department of Housing and.
Fellow, we make him a party by name. Because if tomorrow, if it is found that the petitioners have been evicted, he has to pay the entire compensation. This is the law.
Something lordships may consider.
No,
So that is.
I am not going to. First of all, you don't have your pleadings.
So read petition itself.
I am not going to look into all these things. There is a Kiraz periodic patta here.
The page 54 of the writ petition, my lord, the notice was issued twice. The petitioners, only on dag number 198.
But
They
lordship-
admitted case that they received the notice, they did not.
Mr. Ganguly, let me tell you one thing. Sitting in this bench, I know what is actually happening. You may issue a notice under 198 and
And
evict him from his own land. It also happens.
That power.
It is not the case of the petitioner that the petitioner is in possession of 198. The case of the petitioner is in possession of their patta land.
That is a disputed question, my lord, which the state only can clarify by a. land
That is the question which they have not clarified.
report.
That is why I am asking for the trace map.
The responding number 4 in his affidavit has clearly denied that, and no rejoinder has been filed, my lord, by the petitioner to them. Respondent number 4, my lord, I have just seen the affidavit filed with the circle officer, clearly stated that they have been evicted only from the tag number 198. my lord. That is absolutely clear. To that, they have not filed any rebuttal, my lord. That not.
Not necessary.
Otherwise, it's a disputed question of fact.
So what?
I leave it.
226, we can look into that also.
Yes, ma'am, two hearings. Two notices of hearing.
Understood. It was given in 198 and they have been dispossessed from the patta land. This is
My instruction is
question
that,
of
my
very
lord,
importance.
They are very much in the patta land, my lord. Only 198, my lord. There was nobody on the this 198. 198 is only the taking is done, my lord. Nobody is there in the 198. It's a government land. He has no right there. He also has to show his locus standi.
That instruction paragraph number 2, lordship, regarding the doc number 198, that have been mentioned. It is a government land. Recorded the government land.
Madam, Mr. Hendy, kindly appreciate one thing. The allegation of the petitioner. Allegation of the petitioner is they are the owners of this land. They have a periodic patta, and this patta land they have been evicted in the name of 198. Isn't that your case? Then, barely by stating that we have only done in 198 does not answer the question. The question is, you have to show when 198 is and where is the petitioner's land and whether they are. They have not mentioned. You have given an instruction who has no head and tail. How can there be dark number 266 is in the possession of one occultanti? Who is occultanti? You are there. This patta has been issued in whose name?
Kindly come to the page 23, annexure B. That 198 dark is not mentioned in the Bangladesh periodic pattern.
Understood, because it's a government land. Their basic case is that they are the owners of their land. They were residing over the land in the occupation of their own land. In the name of 198, you have done it at the behest of them. The answer.
Trace map reveal. The trace map will reveal actual position. Their patta land that is the north of that. We are doing pretty good.
The case projected by the petitioner is that the petitioners are the owners of an area of 21 bighas 10 lectures, isn't it?
Yes, sir.
Covered by patta number 49. KP patta number 49 and 21 bighas 10 lectures included in and covered by various darks being dark number 201, 240, 269, 272 and included in KP patta number 49 of village number 2 Sonmilani within Dhekiajoli Muza in the district of Sonipurasan. It is the further case of the petitioner that the petitioner have been paying the land revenue from time to time. However, the respondent authorities, more particularly the then circle officer, in concert in collusion with the respondent number 7, na?
Yes, Lordship. 7, private respondent.
Respondent number 7 have dispossessed the petitioner in the name of taking steps for eviction under Rule 18 of the settlement rules. The counsel appearing on behalf of the petitioner submits that the notices which were issued pertain to dark number 198, which the petitioners also duly admit the same to be government lands. However, in the name of carrying out eviction in dark number 198, the petitioners have been evicted from their patta lands. It is under such circumstances the petitioner has approached this court. The learned counsel further referred to the affidavit in opposition filed by the respondent number 5, wherein it has also been admitted that a complaint was filed wherein it has been mentioned that the petitioners filed a complaint against before the Deputy Commissioner Punitpur against against the respondent number 7 and others. On 18/1/2018, the additional Deputy Commissioner sent it to the OC, the casually PS, to cause an inquiry as well as to submit a report in the matter. On receipt of the same, a non-FIR case was registered by Rai Kashmari OP number non-FIR case number 1/2018 and inquired the matter. So further to that, on 30/1/2018, the non-FIR proceedings under 107 was submitted to the Deputy Commissioner Punitpur. The legal counsel further submitted that in paragraph number 5 of the said affidavit, it has been categorically mentioned that the then circle officer Sri Sabhyashashi Kashyap on 30/3/2018 arrived at Rai Kashmari OP and asked a police party to conduct eviction in the disputed land. Accordingly, 1 ASI, 1 UBC, and 1 section of armed forces were detailed and sent with the circle officer to maintain law and order during the time of eviction. And in that regard, a GAD entry was also made. The learned counsel further submitted that the affidavit so filed by the respondent number 4 does not deal with the case so alleged in the writ petition, inasmuch as it has been mentioned that the respondent number 4 had exercised the power of eviction only in respect to dark number 198. The learned counsel submits that the case involved in the instant proceedings is as to whether, in the name of carrying out eviction in dark number 198, eviction was carried out in the land of the petitioners, periodic patta lands of the petitioners. Today, Mr. J. Hundik, the learned counsel appearing on behalf of the respondent, submitted an instruction. The same instruction is, however, not clear as to whether the eviction was carried out in dark number 198 or in the patta lands of the petitioner. Under such circumstances, this court directs the district commissioner, the Punitpur, to place before this court a report on 17th of December 2024. Along with the said report, the relevant trace map wherein the eviction was carried out and wherein the lands of the petitioners, as seen in patta number 49, be duly indicated. List accordingly.
Item 7 to 11.
What are these matters?
Matters regarding fixation of price of the RTC.
Huh?
Fixation of price of raw petroleum coke. Now, as per the instruction of the government of India.
But my humble submission before your lordship, my lord, matter this, all this matter has become infractious matter. Nothing to be survived in this matter.
Why?
This, they have challenged the auction of raw petroleum, RPC. Their allegation was, my lord, regarding, my lord, violation of Government of India guidelines for auction of the RPC. We have followed all these things. And in fact, my lord, auction has been held and they have participated in the auction process and the materials were disposed of. Then thereafter, my lord, new circular has come regarding, my lord, sale of RPC. The earlier process, on the basis of which, my lord, that is 7 of 2012 guidelines, that has no longer in force now.
Day after tomorrow.
So now there's a new guideline.
Yes.
What is the guideline? E-auction held.
Yes, but this noble court has held, my lord, that will be subject to, my lord.
Who held?
This noble court, my lord, prior to that.
Has the e-auction happened?
Yes, my lord.
Did you participate?
Well, participated because of the honorable court's order, my lord, that it will be
So
subject
if
to
you
the.
have participated, then what remains?
No, my lord, it's subject to, my lord.
Huh?
That is subject to, my lord.
So
yeah,
what?
my lord, that's-
You have participated.
No, participate, my lord, but this is subject to order because
Now there is a new guideline, guideline for sale of raw petroleum.
so that is different, my lord, now.
Why?
That is because we are on that, my lord, guideline.
Why we should go carry out some exercise which is absolutely not
No, my lord,
necessary now?
that is there, my lord. I shall place, my lord, that, my lord. So that is why.
In
my lord,
view
I
of the
place, my
above, the
lord.
following guidelines for sale has been approved and HO and so administrative in so and so. This comes into effect from 1st of February 2021, superseding all earlier guidelines.
Yes, that.
So these 7/5/2012 and 26/10/2012 is no longer there.
Yes. So now, my lord, I'm not on that, my lord. Earlier, my lord.
What are you going to get now? What is
My
your
lord, we
prayer?
have
Let
to
us
get,
see.
my lord, back the money, my lord.
No, no, let us see the prayer.
Yes. No, not the payment subject to, but.
No, no, let us see the prayer.
If your losses held, my lord, that this fixation of price is not correct, my lord, because this loan court has in several orders I said place that is high, my lord, so far I say Guwahati is concerned, Guwahati file is concerned. Then, my lord, we shall get back some money, my lord, for who should put my file.
Let us see the prayer.
No.
Yes, my lord. Prayer.
Let us
prayer
see
is
the
very
prayer.
important.
No, prepare, my lord.
No,
because,
no, no. Mr. Sayola, finally come to the prayer.
Yes.
Why a writ in the nature should not be issued for interfering with the aforesaid arbitrary and illegal action of the respondent in not fixing the floor price
Yes.
of the raw material
Yes.
coke in terms with the guidelines dated 7/5/2012 issued by the Ministry of Petroleum
Yes.
and Natural Gas, as
Yes.
well as the order dated so and so passed in Iman. And why a writ in the nature of mandamus be not issued to formulate a pricing policy before fixing the basic price of raw petroleum in terms of the guidelines issued by the government of India by notification dated so and or why a writ of mandamus should not be issued directing the respondents not to proceed further with the e-auction scheduled to be held on so until and unless the reserve price is finalized at par with the import price
Yes.
and other refineries of the state, and why a writ in the nature should not be issued setting aside and quashing the e-auction scheduled to be held on 7/8/2019. So what remains now?
No, my lord, that is, your losses must see.
E-auction has already taken place.
No, that is why, my lord, page 43, my lord, you also see the order, my lord. Page 43, or the portion as a page 45.
Yes.
You see, my lord, after hearing the counsel for the parties on due which has been made clear that each and the process to alert the RBC party is subject to outcome of the distribution.
So,
Prior to that, my lord, this honorable court held that, my lord, it is a high, my lord.
so what? As of now, e-auction is finished. As of now, you have a new circular.
My lord, for that, my lord, your loss is to see, my lord, whether that price was, what refinery was high or not, my lord.
What, no, let us assume that the price is high. What can this court do in this?
No, only, my lord, that observation, my lord, we can go for suit, my lord.
Huh?
We can go for suit, my lord, for recovery of that,
Suit.
my lord.
But why should this court hold
No,
it?
that is to be, my lord, because that is why this honorable court held, my lord, that will be subject to, my lord, outcome. Because, my lord, at page 45 itself, my lord, you'll also see. Not here, my lord, another. My lord, this is page 41, my lord. Page 41, paragraph 11. Paragraph 11. Page 41, paragraph 11. In that
40?
context, reserve price of RPC, 4 refineries said may be examined. While it's true that reserve price of RPC
is variable and depend on various factors, but taking the general pragmatic view, court is of opinion that in spite of such variation, the pricing range of the RPC in the four refineries should not be so diverse so as to make the whole process to look quite arbitrary. Digboi refinery, Guwahati refinery, Blangan refinery belong to the same IOCL family, producing more or less similar quantity of RPC. If the reserve price of RPC at Digboi refinery is 19,000 so and so, and Bongaigaon refinery 19,000 so and so per metric ton in the last auction, it defies logic as to why the reserve price of RPC Guwahati refinery should be fixed at rupees higher price of rupees 27,000 and odd per metric ton. In so far as NRL is concerned, its earlier fixed reserve price for RPC is 28,300 per metric ton. But after the order of the Sonal Court on 6/2/19 as extra above, it has reduced the price RPC by rupees 7,000 per metric ton, fixing at rupees 21,300 per metric ton. In the light of the above,
Show me under what provision you were saying about the reserve price? Where is that order of a reserve price?
reserve price, they have to declare before the auction.
Huh?
Because as per the guidelines, if your losses see the
Where is the
guidelines.
guideline?
Hello,
Here.
Ah.
Page 27.
Page 27, madam. And director says the
Director
auction
said the
form has been
issue of the
examined by
state
ministry,
economy
then decided the auction should be preferred mode of sale of
Commission.
RPC to ensure maximum revenue, import parity price, so and so, should be used as floor price of the bidding process. In order to facilitate equitable distribution, ensure that local industries are given preference, the auction may be restricted to units within the state. The auction process should be initially completed in 2 months and periodically thereafter. The auction will be conducted at adequate frequency and the quantities it should exceed installed capacity. So and so.
It's very clear in the guidelines itself, my lord. So, to ensure maximum revenue, the import parity price, which margin, quality, differentiates materials, marketing cost and margin and other necessary adjustment.
Can we come to page 35, paragraph 15 and 16? No direction to that effect. Okay. Forget about this. We dismiss it without that. You have no peace. No peace.
Paragraph 55.
Paragraph 15, 16, to page 35.
34 and 32.
I'm looking into this case. What is called 5703.
That's NRL case.
This is the basis on which the entire case is.
Yes, my.
Because paragraph 15, the NRL is a public sector undertaking, though it has a generate revenue and earn revenue at same profit at time. It is to ensure that the local purchasers of RPCs are not put to disadvantage by keeping the reserve price of RPC in the e-auction quite high. While the stand of the NRL that the reserve price of RPC in the next auction will be kept low, then the reserve price of RPC auction by the Guwahati annually is certainly a welcome and appreciable. And it may also examine feasibility of scaling down the reserve price, keeping in par with the import price of RPC. Beyond such observation, it may not be proper for this court to venture into matters requiring technical expertise. Court hopes and trusts that the NRL will look into the above aspect of the matter while conducting its new auction.
Well, that is, my lord, 7,000 has been reduced. After this
That
order,
is up to my
7,000 has
lord
been
NRL.
reduced by NRL.
Then,
My lord.
then,
And they to solve that at that
then
price.
they again made it 21,000.
My lord.
Then they made it again 24,000.
And
No,
in paragraph 13
But
also.
can this court
Well,
direct them? Then look here, you reduce it. No.
well,
And that too, that e-auction happened a long time back.
2019.
parity of the price, my lord. Parity of the price, my lord. Parity. My lord, they four
No,
refineries.
Mr. Sahiwala, why are you not understanding that
Yes.
2019 e-auction is long over? Now you have a different circular. What remains in that e-auction? You may make it subject to. It is the happiness which a council may get with that one-liner. Otherwise, that had no meaning today. Yes, it would have happened in respect to those, means if it is a contract which has already been completed, making it subject to, it makes no sense. Can this court today say that yes, the price should be 7,000, so refund them that? Where is your prayer?
There is no such prayer in.
Well,
Where is your
that's
prayer?
because that was originally, my lord, it was, my lord, reply we have said so, my lord.
Reply can't be a prayer.
My lord.
Where is your prayer to that effect? Nothing is there. You know,
My lord, prayer, my lord,
dismiss, withdraw, which one? In view of the new circular.
well, let it come day after tomorrow, I shall take instruction. my lord.
Tomorrow, not
Yeah.
day after. Day after, too many matters. Tomorrow, 2 o'clock, get your instructions or we dismiss. Matter have been substantially heard. Full stop. D.K. Sharma appearing on behalf of the. You appear for whom?
My lord, I am for all the respondents except my lord one, my lord.
Who is all the respondents? Whole India. NRS.
IOCL, my lord, Indian Oil Corporation.
Appearing on behalf of the Indian Oil Corporation submits that the heard the learned counsel at length. Full stop. Mr. D.K. Sharma, the learned counsel appearing on behalf of the
Four. Four.
Appearing on behalf of Indian Oil Corporation has submitted that the instant repetitions have already become infractions. Full stop. He submits that the circulars dated 7/5/2012 and 26/10/2012 have already been superseded by another guideline issued on 29/1/2021. In addition to that, the Learned Council had also submitted that the e-auction which was held in the year 2019 is long over, and as such, nothing survives in the instant repetition. Mr. G.M. Sahiwala, the learned senior counsel appearing on behalf of the petitioner, submits that he would take instructions in that matter. To list this matter again, date to the at 2 p.m.
Item 13 and 14.
Yeah, please, Lord. Lordship, I have received the affidavits.
Yes, madam.
Yes, your lordship, I have filed my affidavit as per the previous order dated passed by this honorable court, your lordship.
The
Uh,
file
lordship,
affidavit
we
when?
filed verification yesterday, your lordship. We were
When did you file your affidavit?
yesterday, your lordship.
Ms. So-and-so appearing on behalf of Revenue
Revenue Department.
submits that an affidavit has been filed in the matter. However, the same is not on record. List this matter on 9th of December 2020.
Regarding the verification, your lordship, there was an odd direction, your lordship.
Let the affidavit be on record. The registry being on record.
I'm obliged.
15.
None appears on behalf of the petitioner on call, list this matter moving.
16.
Yes, Mr. Sharma.
Under object. Today's company that the reservation of some hectares of land. That is another, there is a letter to be circumscribed by the DFO for joint survey. And now.
Yes, what is it?
As far as de-reservation is concerned, that cannot be done, Lordship, without the permission of the Honorable Apex Court. Otherwise, for survey, Lordship, I have been instructed that with the district administration, the forest department is going to do a survey, and but otherwise it is an admitted fact that the petitioners are inside reserve forest.
How long?
We are since, in fact, since 1962, after the Chinese War, those retired and those injured and.
They not come within the ambit of the other forest dwellers.
That determination has to be done by the nearby Gram Sabha. No such determination has been annexed in this.
Why it is not being done?
But
Because if they are there, are you ST? No.
We are 90% Gorkhas, there are some other castes.
Gorkhas won't be ST. Is ST in Assam?
No, not.
Gorkhas are not ST. So the question is that if you have to come within the ambit of other forest dwellers, then as on 13 to 2015, 5, they have to be there 75 years.
75.
Were they? No.
75 is not right.
And Lordship, they have
So
to be,
therefore, they don't come under that act.
they have to be dependent also. Their livelihood also has to be
Yes.
dependent on.
That is one thing.
Yes.
Dependent or not, that the Gram Sabha will look into it.
Yes.
But the fact that they are not 75 years, nothing happens. The three
Now
generations.
only 62 years
That
now.
itself.
They let the process, my lord, because under section 2
So
of the.
unless there is a de-reservation not done, the current question of
Yes.
settlement does not arise.
No,
So, my lord,
So you have made the proposal for de-reservation.
that Lordship, as Lordship knows that it is, as far as this forest is concerned, there is no such proposal for reservation.
So unless you don't do it, how can you allot?
Exactly, that cannot be allowed.
first, my lord, they have to conduct a survey, then determine what is the extent of land. Because your lord, if your lordship has seen the report of the.
So are they to be evicted?
They'll have to be, Lordship, because they are inside reserve.
my lord,
Have to
this-
be
this report,
evicted. They cannot be used for non-forest purpose. And they don't come within the
And
forest village.
Forest building.
The request of the council for the forest. This stands adjourned. For taking
Out of
instructions.
22,000 hectare land, my lord, about 16,000 has gone into encroachment. Only 8,000 remains.
Mr. Sharma, the question is first, whether the reservation was done properly. You are not assailing that. Secondly, if it is reserved, to make it de-reserved by the government, section 2 of the 1980 Act has to be followed. For the purpose of making the de-reservation, in order to make the allotment, the government also have to have the fund. The revenue department has to have the fund for making payment for compensatory afforestation. Number 3. Then they have to also reserve a similar area in another place. Number 4. All these things are to be done.
In fact, my lord,
The easiest thing, to evict.
and in fact, my lord, 3 years of the reservation done within the
Is the
forest.
matter after 4 weeks. I may not be sitting, so in that bench, then
18 and 19.
what is this?
Thank you, sir. Your Lordship, pass over for the time being.
When did you submit?
We have submitted.
These
the-
lands you want to transfer to commercial.
Yes, Lordship, commercial land.
What happened? You have submitted, why are you continuing the petition?
In the writ petition, there is a direction first to submit fresh application, Lordship.
So what? Now you have submitted what remains in these petitions.
That is, in
Then the authorities are required to do as per that act.
yes, Lordship, they are progressing with the all.
Nothing remains. Close it.
Lordship may keep pending the
Why?
status report, Lordship, maybe.
No, it will be a different cause of action. Can this court, in view of that act, direct, and if they don't do so in terms of section 7 properly, then obviously it is a fresh cause of action.
As
Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that pursuant to the directions passed by this court, the petitioners have already submitted applications seeking conversion, reclassification of land in terms with the provisions of the Assam. What is that act?
Lordship, Assam Agricultural Land Regulation of Reclassification and Transfer of Non-Agricultural Purpose Act 2015.
Full stop. The said application being filed, is being presently under process. So taking into account the above, the instant writ petition therefore stands closed. However, the liberty is given to the petitioner if so aggrieved by the non-consideration as per the provisions of that.
Two writ petitions are there.
এখনৰ নামটো হেল্ল' বহুত লম্বা নাম
Item 20.
19 is similar.
Similar,
19
Lordship,
also
two
similar.
persons, two lot of lands. Lordship.
এটাতে এটা এটাকে দি দিম
I'm
I've
deeply
given you
obliged.
the liberty if you are aggrieved by the non-consideration.
I'm deeply obliged.
Yes, Mr. L.K. Bora, where is he? What is this? What are you challenging?
The petitioner has challenged the resolution.
Huh?
A resolution passed by the respondent that is a government land occupied by the petitioner since 1984. And he was from the days of his grandfather and then father till today. But suddenly the respondent in the year 2021, respondent tried to evict the petitioner forcefully. That the present land in dispute in question is the land belonging to the Gaon Panchayat. The allotment has given.
These
But
are
no-
government lands.
Yes, yes.
You are to be evicted.
Trying to evict it.
They have issued a notice.
Yes.
Where is the notice?
My Annexure 3.
Only the, please accept my
Is the
guarantee,
key at-
hereby
is the
inform
key.
you the land measuring so and so. Then in the name of Betola Gaon Panchayat. In the meantime, the demarcation it is by the authority from that you have occupied a few portion of the group. This is by Gaon Panchayat. Gaon Panchayat can't evict you.
Yes.
Why are you coming here?
That's why they have taken resolution, Annexure 4.
So what?
Annexure 4.
They will do so as per law. They are not the circle officer.
No, yes, circle officer is involving here.
Fantastic. Let the circle officer be hand in glove with all these people. But what remains? What is this type of notice? This notice is not conceived under law.
This matter, my lord, on 14th February 2022, my lord, that Sitha copy and instruction is received from the circle officer that it's a government land. Photocopy of it.
And you are requested to appear in the public meeting and you are challenging all these things.
Yes.
Goodness.
So without my appearing,
That
the
number
parcel
date
is
is meeting filed. The for panchayat.
Whatever may be, the action has to be taken by the circle officer.
Yes,
This type of action, what is he going to do? And this is nothing. Nothing remains. No. You withdraw. Nothing happens. They can't. I would say that they cannot evict it.
but they are trying to evict. That's why.
They will try to evict, then it is a different thing.
Yes.
If they try to evict, then file a suit. You are expert in that. Oh, I file a suit. But how can all
The
these things
objection may
happen?
be recorded.
Huh?
Or an objection may be recorded.
What?
Because the panchayat has.
Ah, it's in the hope.
Is protected by status
The
quo order.
petitioner hearing is aggrieved by the issuance of the notice dated 22/10/2021 issued by the President and the Secretary of the Betoni Gaon Panchayat, whereby the petitioner was informed, asked to appear in the public meeting which was organized on 25/10/2021 at 11 a.m. to find out a proper solution. The counsel appearing on behalf of the petitioner submits that the petitioner apprehends that the said authorities shall dispossess the petitioner forcefully and as such has filed the instant writ petition. It is a well settled principle of law that that a person who is in possession of the law, the possession of a land, can be only evicted by following the due process. Under such circumstances, be that as it may, the issue involved in the instant petition was only asking the petitioner to appear before the authority, in the public meeting to be held on 25/10/2021. And that too for arriving at a proper solution of the matter. Under such circumstances, this court does not find that a case has been made out for interference under the provisions of under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. Be that as it may, this court, however, observes that if the petitioner is to be evicted, the same can only be done by following the due process.
Status quo was there, my lord. Status quo order is there, on 5/1/2022, status quo order was there, my lord.
Interim orders passed
That
and
is
this
Resolution has been taken. Annex of 4.
Whatever it is, if it is a resolution being taken by them, they cannot exercise the power. This is by the PNRD. PNRD has to involve the circle officer. The circle officer then has to issue Rule 18 notice. Rule 18 notice, if it is issued to you, then thereupon you submit your reply and say that I have a better case. So these are all other aspects which will happen when. Nothing remains.
My lord, petitioner husband had made 3 policies, my lord, LIC policies, my lord. He died, my lord. Thereafter, my lord, I made that claim before the LIC authority, my lord. After knowing that, my lord, he had 3 policies, 2 at Guwahati, 1 is at Shivsagar, my lord. Accordingly, my lord, 1 policy they have made to the.
This is the case pertaining to where the amount was not deducted from your account because your account was closed. Isn't this the case?
The response number 7, 8, and 8 is the nominee of the three policies, my lord. 7 is the brother and 8 is the mother. My lord, accordingly, my lord, being a my lord wife, the deceased my husband, class 1 here, my lord, I am entitled, my lord, 50% of that, mother and me, my lord.
That means there are 2 writ petitions.
Only
One.
my lord.
Okay.
So
Tell me.
accordingly, being a class 1 here, my lord, my mother-in-law and I am entitled, whatever it is, my lord, policy amount of the 3 policies, my lord.
Then?
Now they have paid to the my lord brother as a my lord nominee, my lord. 1 policy, some amounts, my lord. And remaining after the court's order, my lord, they keep in hold, my lord, in the bank, my lord. Rest of the amount.
The amount was paid to the brother.
Brother, my lord.
7 and 8.
7 is the brother.
You are the wife.
I'm the wife.
7 is
The brother.
And 8 is the mother.
Mother.
So they are paid to 7 and 8.
Only 7 paid, 8 they are keeping hold, my lord. In respect for 8.
We have filed our affidavit on 13th November. It's on the page 34.
Yes. What is it?
What's it?
So you were the nominees.
Yes, Lordship, I'm 7 is the nominee. seven. is
7 was the nominee.
Seven was the nominee in two policies, and one other one, there are three policies. In one policy, mother is the nominee. Being the nominee, the respondent number 7, the brother got the money. LIC.
Well, who is appearing for LIC? Yes, what is your stand?
Lordships, after maturity policy, already 3 policy already. The brother of the deceased, Kumar Burua. So in 2 policies, the amount already disbursed, and 1 policy in the name
So,
nominee is the mother.
Onju Borua, that is respond number 8 is the nominee of policy number 444707681. Rana Kumar Borua brother is the recorded nominee of policy number so and so and so and so. So they are the nominees.
My lord.
Then what right do you have?
No, my lord, this is that is a state of my deceased husband. I'm entitled, my lord.
How?
Why?
How?
Because my lord, they are done collecting nominee, my lord. In case of brother, my lord, mother is my lord.
No. This is not of succession. It is a question of nomination. The nomination is the person concerned. You have to challenge the nomination in a court of law. But the person of the deceased have already made him the nominee. So what is your case?
My lord, nominee, my lord, as per the amendment of the, my lord, the insurance act 1915, my lord, they are collecting nominee, my lord. They only can collect. If otherwise is not entitled to the property, mother being a class 1 her, she is entitled. But the brother is not entitled. Brother is a collecting nominee, who is the beneficiary, who is supposed to get, he has to give them. And as long as I'm survived, it goes to me, my lord, they are just.
To me,
Supreme Court also, my lord.
I remember there is one judgment that the nominee is only a trustee.
Trustee, my lord.
Show me that the
That's,
nominee is not entitled to the amount.
My lord, may I read for it? And the amendment also, my lord, draft is amended because of this my lord, confusion, my lord. Because who was the nominee, they are utilizing the money. That's why there's an amendment, my lord. Section 19 have been amended, my lord, but my incorporating sections 7 and 8 subsection in section 39. My lord, paragraph 12.
Now, therefore, why should we exercise writ?
My lord.
See, for them to pay, they will only pay it to the nominee. We cannot hold it now that they will be paying it to you. They cannot pay it to you. It is dependent upon you and him that you are entitled to that amount. So it will go as per the succession. If you have a claim, you have to file a claim against them.
Succession, my lord, yes, my lord, is there a dispute that I am not entitled, I have to prove by
But
succession. my lord.
why would how can this court impose upon the insurance company to pay to somebody else? Wouldn't that go contrary to the nomination? Even kindly see paragraph 12 of the judgment. We approve the views expressed by the other high courts on the meaning of section 39 of the act and hold that a mere nomination made under section 39 of the act does not have the effect of conferring on the nominee any beneficial interest in the amount payable under the life insurance policy on the death of the assured. The nomination only indicates the hand which is authorized to receive the amount, on the payment of which the insurer gets a valid discharge of its liability under the policy. The amount, however, can be claimed by the heirs of the assured in accordance with the law of succession governing them. So you have to make a claim against them. Why should this court go and interfere with all these things? It is between you and them.
My lord, that I understand, my lord, but where is a dispute, my lord, there will be the success of
Why
that
should
amount.
this
my lord.
court?
There is no dispute.
No, Mr. Saranya, why should this court at all interfere with all these things? They will make the payment and you claim as per law that you are entitled to this amount. But for them to get a valid discharge, they can have to only pay it to the nominee. They cannot. I'll make the observations to the effect and you will make a claim,
My lord, lordship then
but
comes
not
the,
the
my
writ
lord,
petition.
Provision 39, my lord, that after amendment of the night.
What does it say?
The Insurance Act, my lord.
Insurance.
Insurance
What
Act
does it say?
1938.
Have you quoted the provision?
No, no, my lord, I have not quoted in the petition.
Where is the provision?
My lord, in paragraph 14, my lord. Page 9.
Yes.
My lord. Second paragraph. my
Member of
lord.
a
It may
policy
mention
holder
here.
may, when effecting the policy or any time before the by the policy shall yes. Initiation which have been automatically cancelled. Yes. Which say provision?
My lord, that's amended provision, my lord, 7 and 8 of the 39, my lord.
Yes, what does it say?
May I read, my lord?
Subject to other provisions of this section,
My lord.
where the holder of a policy of insurance or his nomination on his own life nominates his parents or his spouse or his children or his spouse and children or any of them, the nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under subsections unless it is provided that the holder of the policy, having regard to the nature of his title to the policy, could have conferred any such beneficial title, such as aforesaid, that a nominee or there are more nominees than one, a nominee or nominee to whom subsection 7 dies after person whose life is insured, but before the amount secured by the policy or how is it relevant?
My lord, success will come, my lord, if there is a dispute, my lord, who will be the success of that amount, my lord?
You are entitled to claim that from them. But how will they get a valid discharge? Because it contract is a contract is a contract. A contract of insurance is a contract. They have contracted with the insured to the effect that we will be paying you if there is a debt on you to this amount to the nominee. This is the valid discharge.
Right.
How the nominee pays is between you and him. How is it relevant that we should exercise writ?
My lord, if there is no dispute, my lord, regarding the successor, my lord, court can, my lord.
Absolutely no.
But there is no dispute, my lord, that I am not the class 1 here, my lord. So secondly, my lord, another judgment, my lord, I want to refer, my lord. Paragraph. My lord, last 17, 18 and 19 paragraph. Last.
So Sonia, what I am saying is what has been also said here. See, this is not a writ proceedings. This is a proceedings under 372.
There is one judgment of Delhi High Court also. When it
Delhi High Court, go to Delhi.
Page.
They have a branch office there, na? You have a branch office in Delhi, LIC. Withdraw and go to Delhi. They may be bound. I am not bound. Law is very clear. You see, I have to hold them responsible first. Without holding them responsible, I can't bring the case them. Now, for them to get a valid discharge, they have to give it to the nomination. You have a right against the nomination. So I say it that you have a right, and for which you are going to make a claim. I'm making the observation that you have a right.
When I am being a class 1 and legally entitled, but this is transparent, my lord. I have to go for succession, file a civil suit, my lord, claiming that amount, my lord. This is a long process
For
of
succession, and you go for succession certificate before the district judge. But you can convert a 226 for that.
some cases court has interfered, my lord.
Fantastic. Those courts are very good. Or ask the division bench to interfere. I'm not. Heard this time so near the
That, my lord, that the amount which have been, my lord, kept intact, that may be continue, my lord, till my lord, the succession is.
Absolutely no.
Otherwise,
That
my
cannot
lord,
happen
may
because they
dismiss
would
also.
not get a valid discharge. If they don't get a valid discharge, there will be a question of interest. They have to get a valid discharge by making the payment. You may have a right out there. You go and file a 372 proceedings. Heard Mr. M. Solonia, the learned counsel appearing on behalf of the petitioner. Mr. You are appearing for LIC is who?
AL Mandal. AL Mandal.
So appears on behalf of the respondent number
126.
126. Mr. So appears on behalf of the respondent 7 and 8. The issue involved in the instant proceedings pertains to as to whether the petitioner herein would be entitled to a share of the proceeds of the 3 LIC policies which was held by the husband of the petitioner, wherein the respondent number 7 and 8 were the nominees. From a perusal of the materials on record, it reveals that the petitioner married one Rajiv Borua, bracket since deceased, on 24/4/2021 as per the Hindu social rituals. Subsequently, the marriage was also registered and a marriage certificate was issued on 28/4/2022. The husband of the petitioner, late Rajiv Borua, during his lifetime, had 3 life insurance policies insured under the respondent corporation and insured, and 3 life insurance policies issued by the respondent corporation. The said policies were bearing number 486006062, 486008012, and 444707681. It is an admitted aspect of the matter that in these policies, the respondent number 7, and in respect to the policy number 444707681, the respondent number 8 was the nominee. However, in respect to the other 2 policies, the respondent number 7 was the nominee. At this stage, it is relevant to mention that the respondent number 7 is the brother of late Rajiv Borua, and the respondent number 8 is the mother of late Rajiv Borua. Upon the death of the said upon the demise of late Rajiv Borua, the petitioner, the respondent corporation took steps for the purpose of disbursing the amounts to the respective nominees of the policies. The petitioner herein being a class 1 legal heir of late Rajiv Borua, being the wife, approached the respondent authorities for making payment of her share, which the respondent authorities refused. It is under such circumstances the present petition has been filed. From the materials on record, it reveals that this court, by an order dated 10/3/2023, issued notice and provided that till the returnable date, the respondent LIC shall not disburse the sum assured against the aforesaid 3 policies to the respondent number 7. Pursuant to the said order being passed, the respondents have duly appeared and filed their respective affidavits. This court have duly taken note of the said affidavits. The question which arises in this court have also duly heard the learned counsels appearing on behalf of the petitioner as well as the respondents. The question which arises for consideration as to whether the petitioner can claim a right to be entitled question which arises for consideration is as to whether the petitioner who admittedly is a class 1 heir of late Rajiv Borua can claim the said amounts from the respondent corporation or the petitioner is required to make a claim against the nominees whom the respondent corporation would make payment in pursuance to the said in pursuance to the mandate of the policies in question. The law in this regard is no longer res intriga, as would be seen from the judgment of the Supreme Court in the case of Srimati Sarbati Devi and another versus Srimati Usha Devi, reported in AIR 1984 SC 346, reported in 1984 1 SCC 424, wherein the question which was before the Supreme Court was whether a nominee of a life insurance policy under Section 39 of the Insurance Act 1938 on the assured dying intestate would be entitled to the beneficial interest in the amount received under the policy to the exclusion of the heirs of the assured. The Supreme Court, in the said judgment, observed that Section 39 of the Insurance Act 1938 held that mere nomination made under Section 39 of the Insurance Act 1938 do not have the effect of conferring on the nominee any beneficial interest in the amount payable under the life insurance policy on the death of the assured. It was categorically observed that the nomination only indicates the hand which is authorized to receive the amount, on payment of which the insurer gets a valid discharge of its liability under the policy. The Supreme Court further observed that the amount, however, can be claimed by the heirs of the assured in accordance with law of succession governing them. This court also finds it relevant to take note of another judgment of the Supreme Court in the case of Shilpa Sengupta versus Midul Sengupta and others, reported in 2009 10 SCC 680, and wherein the Supreme Court observed in similar terms. Paragraph 17, 18, and 19 of the said judgment is quoted herein in the. From the above materials and record, from the above law as laid down by the Supreme Court, it is therefore clear that merely because of the fact that the respondent number 7 and 8 are nominees of the 3 insurance policies in question, the respondent number 7 and 8 do not have an exclusive beneficial interest over the upon the amounts payable under the said life insurance policy on the death of late Sanjeev Borua.
Rajiv Borua.
Huh?
Rajiv Borua.
Rajiv Borua. Full stop. However, for the respondent insurance corporation, to get a valid discharge, they have to make the payment of the insurance amount of of the amounts payable under the said three insurance policy as per the nomination in the said policies. Under such circumstances, this court is of the opinion that a respondent corporation is required to deposit, is required to make payment of the amounts payable under the three insurance policies to the nominated, as per the nominations contained in the policies. This court also cannot be unmindful of the fact that this court also, taking into account the well-settled principles of law as above mentioned, observes that merely because of the fact that the respondent number 7 and 8 would be paid the amount by the respondent corporation, the petitioner, that would not entitle the respondent number 7 and 8 to the entire beneficial interest of the said amounts, not entitled to the said amounts. It shall depend upon it is dependent upon the rights as per the law of succession governing them. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Number 1, the respondent corporation is directed to make payment
Against two policy already payment was made. Against two policies, already payment was made. And another, only one policy payment was followed up.
Which policies?
444,707.
Mother is the nominee.
Mother.
Mother is the nominee in the policy.
তাতে লিখিব next লেখক তাতে disposed of আগতে It is further taken note of that the respondent that it has been submitted by the learned counsel appearing on behalf of the respondent corporation that as regards the policies, two policies wherein the respondent number 7 was the nominee, the said amount have already been paid. So taking into account the above, the instant writ petition therefore stands disposed of with the following observations and directions. The respondent corporation is directed to make payment of the amount payable in respect to policy number in 7745 in respect to policy number 444707681 to the respondent number 8 within 30 days. Within 30 days from the date of the instant judgment. Number 2. Taking into account that the petitioner herein is the wife of late Rajiv Borua, she would be a class 1 here and would have a beneficial interest on the policies. In the amounts payable under those policies. Liberty is given to the petitioner to file appropriate application before the appropriate, filing appropriate for you see, here the payment has been already made. Then how do you take care of that for them, for 7? How do you have to file a suit? But as regards 8, you have to file
I
372.
will kept, money has been kept in hold in the bank, though they have paid, they have not, I think, withdrawn.
That I will do it. That I'm going to do with the 372. But how do you take care of the 7? Can 372 proceedings be there for 7?
Being a nominee, but that nominee is 7 also,
How will the court direct them to pay?
because he's a minor collecting nominee, my lord, that claim will come, my lord. He's not beneficial. I am the beneficial on behalf of he's receiving, my lord.
Kindly say is para 10 of
কি লিখলে তো? The beneficial interest has a beneficial in on the amounts payable in terms with the policy as being the class 1 here. লিখিলো না? Liberty, the petitioner is given a liberty to approach the appropriate forum, claiming her interest on the amounts payable against the 3 insurance policies from the respondent number 7 and 8. This court further. এই তার আগতে first direction to the issue shall deposit the amount shall pay to the respondent number 8 shall discharge the liability in terms with the policy number so and so to the by making payment to the respondent number 8 after 30 days on the expiry of 30 days from the date of the instant judgment. So I have asked them to pay after 30 days. So now you know what to do.
Maybe more, my lord, 1 month or 2 months maybe.
No.
I'll file my lord immediately.
No, you have to file immediately. You have also right out there, but the problem will happen as regards how do you take it from them? You may have to file a suit against these people, this person, number 7. You see, the money has already been paid. You have a right to that. Till it is there for the 8, you can very well. But how do you take care against 7?
8 to some extent sees
8
entitled
is 8 you can get it. There's no problem for that. Getting a 50% out there, there's no problem. Because now it will require a certificate. After the nomination, you have to get a certificate. So you get it out there. There's no problem out there. But how about 7? Can you get it by way of 372? No. You have to go for a suit.
That's why I have come to court because.
No, I can't. No, Mr. Soroni, kindly appreciate. You mean that I should issue a writ to him, that you pay to him? My goodness.
When the my lord entitlement is my lord specific, my lord, there is no dispute. I'm not entitled. Only thing is that they are the nominee. This is a dispute. What can my lord mold the relief?
Mold the relief and direct whom?
I thought the LIC authority not to 50% of disburse the amount.
That is a different. How do you take it against the 7?
7 my lord.
I'm not concerned with that. That I've already stopped it so that you can go then get it before the district judge.
Holding bank. I think bank also they have instructed it is in whole bank.
some amount.
In respect of 7.
They have also received some amount, not less than 11 lakhs. Lordship, may kindly see.
Total amount will be
para
33 lakhs.
Para 10 of my affidavit, Lordship. They have almost received 7 lakhs. Not from the LIC policy, but from.
However, the petitioner has already received an amount of not less than 11 lakhs from the deceased son of the imam.
There are other
that
service
is
benefit.
different.
That is service benefit.
No, I'm not on that, the other one. Okay. With the above the instant petitions.
My lord, if they have not, my lord, kept in whole, my lord, let them keep in whole, my lord, there are other interest of 7, my lord. My landed penalty, my lord, will do more, my lord.
He said that he has released it. You have released it. Huh.
Because claim is total amount 33 lakhs. Except the other part. Out of only 11 lakh they have.
Mister, I have given you 30 days, you do, or there is always a division bench. Look in there.
High level.
Item 42.
Public rights. We have filed.
If it have been filed, my lord, but it is not.
Yes, how are you going to rehabilitate them? This is a different case, na? This is being filed by whom? Six is who?
Problem number 6 is.
Well, this is a DF, the Forest Department. Forest Department.
Forest Department's affidavit is there only.
Yes. Yes.
It's not on record.
The Deputy Commissioner of Law.
Okay, it is submitted that an affidavit has been filed by the Revenue Department. Revenue Department. As well as the District Administration. Today, full stop. The registry shall list this matter again on 9th of December along with those affidavits.
Okay.
Item 72 to 76.
Yes, madam. Withdraw.
It is a lordship.
Yes, Mr. Da. Yes, tell me. Mr.
Yes,
Kumar,
my
what
lord.
case you have?
My lord, so far section 49 is concerned of the old act now, which because although the land acquisition was done under the old act, but the compensation was paid under the new act under section 94. Instead of 49, the section 94 of the new act will be applicable. Now, so far, respondent number 2 and 3, they have acquired the land for respondent number 4. Now, when the writ petition was initially moved, there was an order from this court that the reconsideration has to be done. Ultimately, the IOCL Limited, they said that they cannot reconsider it because under the this land acquisition package, certain amount was earmarked for that particular acquisition procedure, and that time and everything has been over. Now, so far we are concerned, my lord, your lordship will kindly appreciate. Although section 94, it says that we have to raise a protest before the this land is acquired and all those provisions are there. Your lordship is well aware. But the fact remains is that this is all a legislation benefit for the acquisition process. Now your lordship will see, so far this land of the petitioners are concerned, I do not have some of the record. Unfortunately, because this was moved in 2018, but I have the record of item number 75. Now, if your lordship looks into the affidavit of the
Mr. Kaur,
respondent,
kindly increase your voice.
my lord, just a moment. My lord, your lordship will just give me a
now you're clear. Everybody can hear it. Now, wait. Let me ask you also get knowledgeable from a senior counsel.
Yes, ma'am.
First of all, tell me.
Yes, ma'am.
Whether section 94
Yes, my lord.
have been legislatively incorporated into the 1894 Act? No.
Not, I would say not.
No. Mr. Kumar, let us go as per law.
Yes, ma'am.
Section 24(1)(a) only says
that
if an award is not passed within a particular period or coming into effect of the act, only the provisions for determination of compensation would be taken into account.
Yes.
Okay.
That's why, my lord, yes, I have
So
seen one
from
of your lordship's
26 to 30, it will be taken into account.
Yes, my lord.
So that has been legislatively incorporated.
Yes.
Okay. Now, if you see the Indore Municipality Judgment, Development Authority judgment, it categorically says that the question of returning the land does not arise.
Yes, yes, my lord. Your lordship is.
Law is very clear on that. Unlike which is there in the new act. If you don't use it for 5 years, it can be returned.
Yes,
So that option is not there.
Yes, my lord. Your lordship is correct.
Thirdly, when there is a possession being taken, award passed and possession being taken, the land vests upon the state which is now being given to them. It is irreversible. Paragraph 116 of the judgment of in Indore Development Authority.
Yes.
Okay.
Yes.
Now, what you want out here is this. You want that this court should direct the state to acquire the land from IOCL so that they can make it a public road for you.
No, no, no. My lord, that is not. Subject to correction. My lord, what we want, if your lordships appoint a commissioner, subject to your lordship's approval, the commissioner can go and see the land because ultimately the land is now landlocked. There is no ingress and egress to that land.
Mr. Kaur, if you have been aggrieved by the fact that because of the compensation, what has happened, the land value of the land has diminished on account of this becoming a landlocked, you can very well claim compensation as per law.
No, my lord, I am on the usability of the land more because now the land.
No,
has
you are usability of the land means it has become useless.
That's why.
For that, if you want a road out there, the land has to be acquired.
Not, I would say, my lord, the land usability is now say 0. Now, if the land usability is not there, my lord, we have to find out a solution, my lord. That how can this land be made usable?
The solution
It's
is
not that
there very
I-
much
I-
in the act. No,
That's
no,
why-
Mr. Kumar, the solution is there in the act. The solution is you have to claim compensation for the land if the usability has become 0.
Yes, but only
You
there.
have not done.
Yes, my
For
lord. That's
this
why.
type of repetition is absolutely
My
should be
lord, no,
dismissed.
there is a hurdle because of section.
Unnecessarily filing. And you have filed an application for enhancement of compensation also.
My lord, these are later developments, my lord, because, my lord, if the land usability is say 0 today, my lord, it is not that always, my lord, the landowner should go, claim. My lord, the deputy commissioner also ought to, the collector also had to have looked into.
That is why when the notification is issued under section 4, you were to protest. You did not. You kept quiet. That is why it has been mentioned that when the area is being mentioned, that this is the land, you kindly go. What do you have to say? You have to say that this is not in public interest. You have not done that.
No, my lord, there is a
Then you have the mudat of under section 9. You should have claimed compensation. Look
my
here,
lord,
my
there-
land is
my
like
lord,
this. Kindly include it in the award.
No, my lord, the usability of the land, we came to know only when they constructed the boundary wall, my lord.
We dismiss these petitions.
My lord, what I would request, my lord, is that, my lord, that your lordship will, in terms of 14 of the Limitation Act, your lordship can ask the collector to look into it. These people, my lord,
Absolutely no. The collector has no business now to look into it. First of all, you see the collector comes into play when a section 6 declaration is being given. The moment the collector passes an award, he becomes functions officio.
But a person cannot be, my
Tomorrow,
lord,
Mr. Kumar, do you want, being a senior counsel, that a collector should laugh at my order?
No, no, my lord, a person
No,
cannot.
this is what you are asking.
No, my lord, my humble submission before your lordship.
Don't ask for something. We expect you,
citizen
Mr. Kumar,
cannot
you
be
don't
made-
ask for something. To
My
that
lord, a
effect.
citizen cannot be remedialist, my lord.
Huh?
When And a citizen cannot be remedialist, my lord. There has to be found out some way, my lord. His right to ingress and egress to his property has been obstructed, or there's no way
If
to
that
go
land
to.
has been acquired and you ought to have therefore approached the collector for the purpose of making a reference.
We do not knew the perimeter of the land until the land boundary wall was constructed. When we
So
came
therefore you are
immediately.
entitled to the compensation.
Yes, my
Of
lord.
the
That's why
land.
we. Yes.
Go there. You should have done that. You have not done that.
No, my lord. We came before this honorable court to stop the construction of the boundary wall.
So
and that's why the court.
How can this court stop this construction?
So that's why the court gave an option to us that you approach the collector and ask for a reconsideration, the IOCL for
The
reconsideration.
collector cannot, you cannot approach.
No, no,
If the
IOCL,
court have said that approach the collector,
No, no,
the
to the
meaning
IOCL
thereby
purpose.
the collector in terms with section 18.
No, my lord, no, the court directed this honorable court directed to approach the IOCL
Mr.
authorities.
B.D. Kumar, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioners, Mr. Yes, what is your name? P.B. Bharadwaj.
P. Bharadwaj.
Mr. P. Bharadwaj, the learned counsel, appears on behalf of the IOCL or oil.
IOCL, my lord, respond now.
IOCL. Mr. A. Bhattacharjee appears on behalf of the Revenue Department, and Ms. M. Bormon appears on behalf of the District Administration. Full stop. The three petitions. Three petitions.
My lord, there are 5.
The 5 petitions filed. The 5 petitions, the instant batch of petition, are filed by the petitioners who are aggrieved by who are aggrieved by the acquisition of the land in LA case number 7/2011, who are aggrieved by the acquisition process carried out in connection with LA case number 7/2011, whereby their lands have become landlocked and unusable. The case of the petitioners, therefore, is that this court should issue direction upon the respondent authorities to spare a sufficient portion of the land for passage for free egress and ingress from the main road to the left out portion of the acquired lands by the petitioner, of the petitioner. Pursuant to the filing of the instant writ petitions, this court issued notice and further observed that the petitioner may approach the respondent, the Deputy General Manager Operations, State Office Nunmati, to explore the possibility of a negotiated settlement. And if such a move is taken by the petitioner, the respondent number 4 would also explore the possibility of such an amicable settlement. The record further reveals that the approach made by the petitioners to the said official of the respondent corporation did not meet with a favorable response. Under such circumstances, the question arises as to whether the petitioner herein, whether this court, in exercise of the powers under Article 2 to 6 of the Constitution, direct the respondent authorities to spare a sufficient portion of the land which were acquired for passage, land for passage, which was acquired for free egress and ingress from the main road. It is a step, it is a settled principle of law that when pursuant to an acquisition proceedings, when in an acquisition proceedings, the award is passed and the possession has been taken in accordance with section 17(1) of the Act of the Land Acquisition Act 1894, or under section 16 of the say Act of 1894, the land vests absolutely upon the state without any encumbrance. It is also seen that pursuant to the said land, vesting of the land also have been transferred, have been handed over to the respondent corporation. The land further has also been mutated.
That information. That information I don't have, man. But all the constructions are complete.
The possession have been already handed over, and possession accordingly have been handed over. Mr. P. Bhardwaj further submits that all construction activities in the meanwhile have also been completed. Under such circumstances, in the opinion of this court, the question of any issuance of a writ as sought for in the instant proceedings does not arise. Accordingly, this court does not find any merit in the writ petitions for which the same stands dismissed.
We are obliged, Your Lordship, for allowing us to appear online.
After tomorrow, yes. Probably it will be covered by that.
Section 148 notice was issued. There is a stay.
They file application that was rejected.
As per the?
They file application, they raise objection for issuance of notice that was rejected by speaking order. Thereafter, they approach this honorable court. One of the ground was that there was a delay in issuing notice. Rajiv Bansal case, Lordship Court has granted liberty. They will maybe taken up day after tomorrow.
Kept it tomorrow.
Huh?
On Friday, Lordship, will be taken. Copy just I have obtained after few hours.
What is the ground of challenge?
Your Honor, may come to page 49, Your Honor, para 12.
Yeah?
Para 12, Your Honor, page 49.
Yes.
And it is written, taking into consideration the fact of the case, the legal provisions as analyzed above, and in the light of the ratio of various judicial pronouncements as discussed herein, it is clear that there was proper reason to believe on the issue of unexplained expenditure of rupees such and such. Your Honor, there was no reason to believe, Your Honor. If Your Honor your Lordship comes to page 27, that is the finding of the AO, assessment officer. May I read, Your Lordship? In presence of such inconsistencies in the lease agreement, possibility remains that no agricultural operation has actually been carried out. Lordship, it is possibility remains. There is no reasonable belief.
Then?
Then at para 4 of the same page, point number 2, due to inconsistencies of land lease agreements, possibility of actual agricultural operations need to be examined. You know, we have filed our objection to that effect that was rejected.
Yes. So what do you mean by reasons to believe?
Worship, we have submitted our objections to the report. Worship, that was rejected.
If it is rejected, then you file appeal against the assessment order. Isn't it?
Only one notice under 148 has been issued.
Huh?
They have not filed their revised return. At the stage of notice, they approach this honorable court.
They should have done for GK drive checks. You have filed your return. Then only anything will be there. They will consider. And thereupon any order is being passed, then you file an appeal. These are questions of facts. What case you have? Reason of belief cannot be said to be a result of certainty. It is a different thing. One thing also has to be taken into mind that reason of belief also means there is certain foundational aspect there. That's it. He has a foundational aspect to that effect, which is categorically mentioned out there to that effect that earlier, however, the closing cash balance was so and so, including the check not encashed at the end of so and so. This indicates that the SSC has overstated the agricultural invent to the extent by not disclosing additional expenditure to the tune of rupees 19 lakhs made during the previous year. The income can be treated as unexplained and rupees as the tax applicable. Then, what case you have? What do you say about the 151? This was done when? 13-14. When did you issue the notice?
It was issued on
Approval under 151 given by PCIT. This is after 13-14 will be 31st of December, 31st of March 2014, isn't it? And when did you issue this?
for 151 was issued on 26/3/21.
21. So 21, if you have issued it, then it will be, has to be by the PCIT,
Yes.
isn't it?
Yes, sir.
If it is more than 4 years, then it is PCIT.
Okay.
Less than 4 years is the assistant. So no case out there. Doesn't have a case.
Yes, not that they have not.
Well, what case is this? At the end of the day, Mr. Counsel, are you aware? You'll be, your client will be, have to pay more, sell out more interest. Yes, what were you asking for?
Friday, Lord. Friday.
Huh?
On Friday.
Why?
Because I didn't have copy. I just obtained. Obtained the copy just before. And Lordship, one point regarding that, regarding limitation, they have raised this question also. So that is covered by recent judgment of Rajiv Bansal case.
Which case?
Rajiv Bansal's case. Union of India versus Rajiv Bansal.
How?
Because limitation was extended by, and Supreme Court says that department is also entitled to extension of time.
Under that act. That taxation specified there. Tola. The limitation was extended because year 2014, 2021, in 7 years.
If
You issued the when?
unamended act, it is.
When did you issue the notice?
Notice was, 148 was issued on
148 notice was issued when?
28/3/21.
Huh?
28/3/21.
8/3/2001. That is 7 years. 31/3/70, 14. What does it say? 149?
149 Lordship unamended.
You have the new act.
Lordship, yes. Amendment was effective from 1st of April 2022. Will be under all that. 4 years 4 years, but not more than 6 years, if the value is more than 1 lakh.
So it is 6 years. Then obviously.
If, it will, in any case, if we are entitled to benefit of 1 year by that tola.
From 15/3/2020. So, but when it would have ended, otherwise 6 years, 2020, 31/3/2020. And you issued when?
It was issued on 28/3/21.
28/3/2021, and you get the benefit of that tola.
In any case, Lordship, in any case, the petitioner has no.
Petitioner has?
No case to.
What to do?
Lordship, the matter may be taken up tomorrow.
Why?
If I have to obtain some instructions.
No case. First of all, you did not submit your return. That's the law. At the request of the learned counsel for respondent or petitioner. Respondent. Matter stands adjourned to be listed on 9th of December 2024. Interim order passed earlier shall continue. You don't have a case.
22.
Till then, huh?
Lordship, as per the last order, the state respondents were supposed to carry out an inquiry regarding the possession.
That in IA, my lord, we have filed that bring on record in affidavit, my lord. Addition in IA, my lord. We have filed that report is already in the court, my lord.
IA has been disposed of.
Wanted to bring on record.
What is your case today? Means, have you considered the proposal?
No, my lord. As per report, my lord, the one settlement on DAG 360, which is a government DAG, my lord. As per our report, after that 360 DAG, he has no position, my lord. Another DAG, that is 359, my lord, that is a roadside land, where he has constructed some house, my lord.
359.
359, that is the dispute, my lord.
He's in 359.
Yes, my lord.
Not 360. Okay, consider 359.
That is land allowed under position of public health engineering.
In public health engineering, they don't have money to construct anything. So they give it to her.
In 2015, my lord, SDLSC have resolution on 8/4/2015 for allotment, my lord, but settlement yet
Quantum
not
of
done.
land measuring 3 kata covered by cement.
Was in our favor.
Give his possession in 360, shift to 360. Allow him to enter into possession at 360. It was already approved by the SLDC.
That is
And
in
do you
relation to
require,
360,
but
my lord.
madam, kindly appreciate one thing. Do you require possession, prior possession?
For allotment of land, my lord, he has to possess for some time, my lord.
That's it. Put it on affidavit that there is a requirement of prior possession for the purpose of settlement.
Case of allotment, my lord.
For allotment, please put it. Then what will happen to clause 14.3 of the Assam land policy? It categorically says that being in possession does not give a right. Clause 15 said nobody can enter into possession of government land. And merely because he's in possession, he has no right to get a
Yes, the
settlement.
allotment was done on 8/4/15, my lord. Kindly tell you, sir.
The 8/4, it was approved in his name.
Settlement not yet done.
So under such, consider that 360, give it to them.
Direction may be issued.
Why should I issue a direction? You see, merely because he's not in possession has no relevance. And if you say tomorrow that he doesn't have a possession, put it on affidavit. We shall be very happy.
May be corrected.
Isn't it, Mr. Google? Tomorrow the revenue department will jump up. What has happened? On one hand, you say that he doesn't have a possession, so you are not giving a settlement.
Circle, I am just pointing out the circle officer's report.
Don't come up with that, because the moment you say you have a more bigger problem. Consider 360. The learned counsel, Ms. Emborman, appearing on behalf of the petitioner, has drawn, appearing on behalf of the state respondent, district administration, have drawn the attention to paragraph number 7 of the affidavit filed on 18/4/2024 in IAC number 3754/2023. From a perusal of the same, it reveals that although the SDLAC in the meeting held on 8/4/2015, it was approved that the petitioner is entitled to allotment in respect to a plot of land measuring 3 katha 10 lechas covered by ceiling Sartari Dag number 360 of Tokolai Shah Bagisa, Gao, Gormur, Moza, and the Jorhat East Revenue Circle. However, on the basis of a report of the Circle Officer Jorhat East Revenue Circle, it is seen that the petitioner actually is in possession of Dag number 259. Be that as it may, this court had put a query upon Ms. M. Borman as to whether a possession is essential for the grant of an allotment, inasmuch as the said if that stand is taken, it would go contrary to clause 14.3 of the Assam. Is it outside land? Na?
Roadside land.
No. Is it outside? It is not town land.
Oh my lord.
Then it will be another one. Na? Goes against clause. This is for agricultural purpose. Against clause 1.14 and clause 14.3 of the Assam Land Policy 2019. Ms. So submits that she will obtain instructions and place it before the court on the next date. List this matter again on 22/1/2025. Full stop. Madam, do the needful.
To 25.
What is this?
May I please, your lordship? Lordship item 23 and 25.
Oh, this you want to withdraw. And you?
I'm on.
Withdraw.
No.
He wants to withdraw.
In vexes, matter may be in vexes, Lordship.
23 and 25.
25, Lordship.
23 and 25. Yes, how does your petition remain?
I do not know the subject matter of their case. My case is the particular cooperative society that last held it AGM in sometime in 2019. And 2021 and 21-22, it did not hold the AGM.
Your matter is which one?
That is 24.
Solomon Ali.
Yes.
Yes, who are you?
I am the secretary.
Okay, now
There was a dispute earlier, which has been resolved by the authorities at the department, putting me back as a secretary. Now they again issue show cause notices. I say you cannot, because the board of directors stand dissolved under law for not holding AGM in time unless the term is extended under 130A. On that, the last order was of this court.
Item number A to the PC 1941 and 2990/2022 data matter. The council appearing on behalf of the submits that the writ petitions have become infructuous, taking into account that the fresh AGM have already been held, and as such, nothing further remains in the writ petitions. So accordingly, the writ petition stands closed as it has become infructuous. Interim orders, if any, stand vacated. Okay, now tell me. Now there is a new AGM. New board.
No, the earlier board should not have been functional. The last term, if my lord takes up page 18, 1-8.
Who has issued the so-called notice?
The show cause notice has been issued by the board.
Where?
28.
Are you
I'm a secretary.
secretary? So you are the chief executive.
I'm the chief executive. There was initially a proceeding against me.
You are not a government servant,
No,
a government appointee. Now, who has issued the so-called?
Show cause is issued by the chairman, Nayaralga Samiti Limited.
Or why?
My lordships.
Why?
They have issued a statement that you are to discharge your duties and liabilities as secretary. From the last 6 months. You have not discharged your duties and liabilities and absented from office. And they also issued a letter of warning to me. That you
Then?
reply and etc. I
Then?
say this is at the most a dispute under 49(2)L between the board and the secretary. The registrar has the authority to take a call, number one. But for the board to have a jurisdiction, the board must be one having jurisdiction as per law. Since by the record, you did not hold, your last AGM was in 2019.
Now, new AGM has come. New AGM has been held.
That is why they have withdrawn the registration, my lord.
Where is he?
I do not know their case.
No, Mr. Talukdar, if there is a, because he has withdrawn this on the ground that a new AGM has been held. If there is a new AGM, doesn't the board have the power under 38(2)?
Power,
That he, whatever it is, who he is, he serves at the pleasure of the board.
Correct.
And what business he has for filing these type of writ petitions?
but without jurisdiction, they cannot issue any notice to me, my lord. The board.
What notice? Why do you require notice?
49(2)L, with all humility, my lord, is a jurisdiction to be exercised by a board in power vested by the right under the act. If they fail out on the touchstone of section 39, they fail on the touchstone of jurisdiction.
Where? Where does 49?
39.
39(2) is what?
No, I'm on 39. 39 AGM.
AGM is okay.
If they have failed by not holding the AGM, then the board did not have the jurisdiction. Board got dissolved by operation of law. Now, in a period when there is
So therefore, now if the AGM is there
yes,
and a new body has been formed,
that they would take a call in their wisdom, but the notice has to be set aside.
what notice?
The notice issued to me, which is under challenge, and I prayed that a departmental officer be appointed to take charge of the meeting.
What notice?
Board.
You are asked to so cause why initiate a direction, board should not initiate action against you under your subleader. Why notice is required to you? You serve at the pleasure of the air. This is no 309. Article 309 doesn't
But so
apply here.
far as the even if I take it the way the lordship is projecting it, my lord, then also the board has to be a board under exercising jurisdiction. If there is no board,
Mr.
one
Talukdar,
can
kindly
approve it.
find out whether, we'll have it tomorrow, 2 o'clock. Find out whether new board has come. Resolution passed. We then dismiss his petition. There's no business out
But
there.
on the touchstone of this, they cannot proceed. New
It's
board
the
can
matter
proceed
tomorrow
extra.
at 2. If a new board has come, they will take action, whatever it is, as per law. He's saying about that at that time board was not there. The
Very
board
good.
are
New
going
board
to
is-
liberty.
new board is
And
there.
the so-called notice has been issued by some, so they can, in fact, why so-called? What so-called?
But
No
we,
so.
but to that, my lord, my submission will
You have
49
no so-called business. You serve at the pleasure of the board. The board in a resolution can appoint, nominate, elect, as well as remove.
But 49(2)L comes way, my lord. 49(2)L comes way. It is not, they
What
say,
is
you did this
49(2)L?
throughout.
No, no.
49(2)L says, it's a dispute whether I do my duties or not.
Where 49(2)?
L.
2L, civil is power,
Will was a
2L.
dispute, my lord.
2L.
You don't
In
discharge your
case
duties.
of
They
a
don't say you do
dispute
this thing
between the
back.
chief and the board
It's
in
as
any
vague as
matter,
possible.
the decision of
Because
the
they-
register shall be binding on both. Okay.
Board approaches the registrar then. I am put by the authority.
No. If it is a dispute out there, the register, the decision of the register whether it does or not, that is immaterial. The power which is there under 13(8)(2) cannot be controlled by 49(2)L.
Well, I
That
leave it
is
to your
my,
lordship. Other than something.
absolutely. We'll have it at 2
Under what
tomorrow.
circumstances,
We
39
dismiss your
49(2)L
petition,
gives way
you
to
just find out that.
Applies.
No case you have.
6.
Lordship, as per minus direction, we have to file affidavit. Within a period of 2 days, we will file lordship affidavit. Today I have
Counsel appearing on behalf of
Deputy Commissioner, District Commissioner.
district administration submits that the affidavit will be filed within 2 days. This matter again on 11th of December. In the meantime, the affidavit will be filed on it. Will be brought on record.
11 December.
Lordship, in this matter, Lordship, and a work order was issued
Huh?
on me, a work order
Ah,
was issued on me for construction, Lordship.
you constructed?
Lordship is 90% is completed, Lordship, 95% is completed.
What do you want now?
Support.
We will be filing the affidavit by tomorrow. Some dispute is there, that will be next week or so. Any day convenient, otherwise.
What do you want, Mr.
Lordship,
Das?
Non-payment of Lordship, the bills,
Huh?
Lordship, non-payment of bills and some additional
Non-payment,
amount,
okay.
Lordship, that I have incurred.
Mr. B. Gogoi submits that the affidavit could be filed. It has already been made ready and will be filed. First of this matter on 12th of February 2025. First of the affidavit be filed by 30th of January 2025. The petitioner would be at liberty to file a reply.
28.
I have challenged the order passed by the Revenue Board, my lord, whereby my lord, our mutation has been cancelled, my lord. What happened, my lord? My lord, here, my lord, the petitioners and the private respondents, my lord, they are brothers, my lord. My lord, our father, long back, my lord, has gifted the property in the name of the, my lord, father of the private respondents, our eldest brother. He has gifted it, and my lord, by way of a gift deed, my lord. Thereafter, my lord, to construct a cinema hall over the plot of land. And my lord, thereafter, my brother, my eldest brother, he has been separated from the family. And subsequently, my lord, he has made, this eldest brother made an agreement to the effect that the property will be equally, it will be equal share of all the brothers. And
After the gift.
after the gift, he has made an agreement to the effect that the property, the land as well as the cinema hall will be of equal share of everyone. The profit and loss will be
also of the cinema hall will be shared by them equally. On the basis of that, my lord, we have, my lord, applied for mutation of our name, my lord, in the plot of land, my lord. Initially, my lord, the circle officer, my lord, rejected our prayer. Then, my lord, we have approached the additional ADC, my lord. He has allowed the mutation, my lord. Challenging that, my lord, they have filed an appeal before the Assam Board of Revenue, my lord. And, my lord, Assam Board of Revenue has set aside that order of the ADC, my lord.
Then what is wrong?
That is, my lord, where now we are before you.
What is wrong with that order? First of all, how does the title confer upon you?
My lord, title, my lord, we have, my lord, when this agreement is made, it is said that, my lord, this property will be equally shared
No,
between
no,
the,
property is being gifted by whom?
by our father to our brother, the eldest brother. That is
Eldest brother.
yes,
Then he enters into an agreement
agreement.
with everybody
Everybody.
and says that the property will be divided in amongst all the persons.
All of
And on the basis of which you have got your mutation.
sorts.
And that mutation has been set aside.
Set aside.
So that elder brother have entered into the agreement.
Entered into agreement, my lord, that we have an expert. The license for the cinema hall also was given, finally given by the authority in the name of all the brothers. That is, at present, the cinema hall
Is
is
the
not
agreement registered?
registered deed, registered agreement.
To me?
That is, annexure 1, my lord, the vernacular is at page, my lord, 13. Title of the property, my lord, is at page 17, my lord. Vernacular one.
How much court fee you have paid? 5 rupees. Registered.
Registered.
Petra Protilipi. Proti- is what? It registered. But tell me, by way of a registered agreement, you are saying this to be a gift. It is in the form of it has to be a gift. It cannot be by way of a agreement.
Gift was given to my eldest brother, my father,
And you see, when a person have a title,
on the basis of agreement.
the basis of a mutual settlement, I would not say it to be an agreement. They have put it as an agreement on the basis of a mutual settlement. Can there be a transfer to anybody?
Petition, my lord, here, my lord.
Huh?
My lord, by transfer, my lord, either by gift or by sale, my lord.
There might be a case, have a look at it. There are some judgments of the Supreme Court wherein it says, when a mutual, what you call family settlement, this is like a family settlement. When a family settlement is registered, I think, if I'm not wrong, a family settlement is to be registered if there is a devolution of certain rights which were not there upon certain person. We consider this to be a family settlement. Then would the right of would the Board of Revenue be right in passing that order by saying it to be mere agreement? You may use the word deed of agreement, but it is maybe a case of a family settlement, which I think so. So it's like a rose is rose in whatever color it may be, isn't it? Find out there. I think you may have a case. There are 3-4 judgments of the Supreme Court wherein it says when a family settlement is required to be registered. Normally, a family settlement is not required to be registered because of the fact that there is no devolution of a right. But when there is a creation of a right, it requires requires registration. So therefore, if this is a document which is registered, it is in fact a family settlement, if it is amongst the brothers.
Amongst the brothers.
And at best, the authority may very well say that court fee has been, stamp duty is less. At best may say, if it is a gift. They may impound the document, and for which there may be a question of payment of revenue, but then also you, which I think you will be ready to do.
Yes.
Analyze that. Okay, list this matter again on when?
December.
Hello, I hear only a first pick, so I put it at 5th of February 2025.
Item 30.
But find out, Mr. Counsel, you have a case in there. What is this?
Okay, non-payment of contractors bill.
Huh?
Non-payment of contractors bill, my lord.
Yes.
We received the affidavit, my lord, from the respondent.
Interim order passed earlier.
Interim order passed earlier shall continue till then. Yes. What is this? Non-payment?
Non-payment of contractors bill.
I filed our affidavit today, Lord. We have filed our
What do you say? You have filed it today. The Sri Sharma submits that the affidavit has been filed in the matter. So list this matter again on 24th of January 2024, 25. The affidavit be brought on record by the registry. Petitioner, if so advised, would be at liberty to file.
31.
Earlier.
Northeast Agro. What case is this? What is this case?
Well, matter pertaining to non-payment of contractual dues, my lord.
Affidavit
20 lakhs.
filed. Reply filed.
A person to the last order, they are supposed to apprise the honorable court today that the central ministry, which central ministry we have to implement, my lord. Because 50% share, my lord, after
Oh, which department?
they are supposed to apprise. Irrigation department. We have received the state share, my lord, of 9 lakhs.
My lord, I have filed additional affidavit, my lord, page 39.
Who is the ministry?
Yes, it is this water resources. Yes.
Water resources?
Water resources, river development, Ganga irrigation.
Jal Shakti?
Page 40. Your Honor.
So which is the department?
Water resources plus see.
Huh? This one. You have to make these as per paragraph 2 of the affidavit filed by on 12th of June 2024. The counsel appearing on behalf of the petitioner seeks for an accommodation to take appropriate steps pursuant to the affidavit filed on 12th of June 2024. List this matter on 19th of February 2025.
My lord, may direct to serve a copy of that affidavit that we have not been served, my lord.
32.
Similar, my lord. Similar, my lord.
Victor.
Lordship 34, item 30, Lordship, where is the contraction, non-payment contractual bill, Lordship. You also file affidavit, Lordship, they admitted the fact, Lordship. Admitted the amount, Lordship.
How much?
Amounts, Lordship.
Yes, why you are not paying 64,000?
Here, Deputy Commissioner has to release the payment, Lordship.
Deputy Commissioner, why you are not paying? Have you made the Deputy Commissioner a party?
No, Lordship, he is not party, Lordship. Deputy Commissioner is the party, Lordship.
And how do I ask the Deputy Commissioner to make the payment?
He is saying that the Deputy Commissioner, he has to make payment, Lordship. Otherwise, Lordship, he.
Who gave the contract?
He gave the contract.
Contract was issued by us, Lordship.
Then you have to pay.
No, Lordship.
We are
We
not
will make the
concerned.
payment, but the fund has to come from.
And how do you get it? How do you hold the Deputy Commissioner by the neck? It is your lookout. But the question is, you have to pay.
Lordship, we have written to the Deputy Commissioner, but there is no reply from him, Lordship.
You are saying there is no affidavit to that effect. Why should we say so?
Lordship, we have filed our affidavit.
The affidavit not here. When did you file?
13/8/24.
Oh, affidavit. Mr. C. Sharma is appearing on behalf of the Water Resource Department submits that an affidavit has been filed. Full stop. However, such affidavit is not on record. The registry shall verify the same and place it before this court. Full stop. List this matter again on 8th of January 2025.
35 and 36.
Yes, what is this?
36, Lordship. Will be filing a rejoinder to their affidavit, Lordship.
File a rejoinder. Counsel appearing on behalf of the petitioner submits that the petitioners would like to file a reply to the affidavit filed by the GMC.
GMC.
List this matter after.
Lordship, we are in 36, so far as 35,
They have filed, my lord.
35 they have filed.
Mr. So-and-so. এইটো এইখন নিয়ত লিখিব হা দুইটাৰে লিখিব Mr. So-and-so, the learned counsel appearing in WPC number 1648
Yes, Lordship.
2023 submits that some time is required for filing the affidavit in reply to the affidavit in opposition. That again on 5th of February 2025. In the meantime, the petitioner would be at liberty. The petitioner of WPC number 168 of 2023 will file the reply.
Interim that may be continued.
Name is there.
Yes, ma'am.
Interim orders passed in both the petitions stands extended till the next day.
Of lunch.
What is this?
So we have, I think, affidavit reply to same person.
Hey.
Yeah, I have filed, so I will copy it to others.
The SK Goswami submits that the affidavit in reply has been filed today. This matter. What is the matter about? Matter about? Urgency? No urgency.
There is an interim operating lordship. In this particular case, I am a contractor. I have executed some work of the railway department. And thereafter, lordship, I have getting supply order from the department. I have not taken any lease from the forest department, but they are demanding 200% monopoly from me. And my bill has been kept intact, lordship.
Huh?
No payment has been released to me because of non-submission of forest royalty.
An agreement in the. Where is the interim order?
Interim order is not to take any
Lordship, there is
coercive.
no- I have,
Huh?
Lordship, I have assured that there is no coercive action.
No, where is the interim order?
The first order.
First order.
Sorry, on perusal of the information has procured the manual in this regard, SK Goswami, they will file a affidavit. Submits that he will inform the rail not to act upon the letter dated 19/3/2000 till the next day. Next day, then
That is continued.
how can it continue? His undertaking cannot be continued by this court.
End of the day, Lordship, they
He has to give an undertaking. Are you giving an undertaking? You say that you are giving an undertaking. I can't continue an undertaking. He has to give an undertaking. You give an undertaking. Tell me,
Lordship, let the matter be heard completely, Lordship.
are you giving an undertaking?
Lordship, on the first day, Lordship, I gave because I had no instruction, Lordship.
Today, are you
Now I have
giving an
instructions
undertaking?
that, Lordship, end of the day, they have to pay the royalty, Lordship.
So are you giving an undertaking today or not?
Lordship, let the matter be heard completely.
No, I'm asking you, if you're not giving, I don't give the undertaking. Because you have to give an undertaking. There is no stay interim. You had only given an undertaking till the next day.
Till okay,
But
till
I
the-
can't
short date may be
continue.
given, till that I'm giving an undertaking, Lordship.
So, okay.
A short date may be given, Lordship. So end of the day, they have bound to pay the royalty, Lordship. That's in the
Forest
Just
department,
a
not to the
matter,
railway.
it has been submitted that an affidavit in reply has been filed. Full stop. List this matter. Let the affidavit be brought on record. Full stop. List this matter again on 10th of February 2025.
Let's.
There is, in fact, there is no extension of that from 31/7.
Extension is there, Lordship. Extension is there. Lordship.
No, see 31/7 onwards, there is not. Whenever a matter comes before me, I don't.
I understand, Lordship.
It's not there. Take it out. There's no extension.
So we have
38.
prayed, Lordship, we have prayed to the court and the court has extended. That may
See,
be,
have a record. Look at the record. 31/7/2024. There is no extension.
May I submit, Lordship? He has assured, Lordship, he is not taking coercive action. Till next
He is
year.
not doing it now.
Agreeing.
Lordship, since July, Lordship, nothing has been done, Lordship, till February also nothing will be done.
Are you giving an undertaking?
No, Lordship.
Then
Item 38.
yes, what is this?
Electrification depth, up to date report was called for.
Madam, have you got the electrical accident report?
Yes.
Now, fresh one.
It is filed by affidavit, my lord.
When?
Same affidavit.
12/11. What is who gets what? Action control.
12/11.
Now, tell me, why is he not entitled to?
Lordship, first of all, I have to take a call on regards to the new, the subsequent report, Lordship. The copy is not served to me, Lordship.
Whether it is served or not, earlier also it was the same report. They have just removed the section.
Yes, my lord.
Why is he not entitled to? You are paying only 4 lakhs. Pay him the 4 lakhs.
Lordship,
There's one judgment. Did you get it?
Yes, my lord.
Where is that? Give it to me. Where it has been mentioned that as regards contributory also, I say that he is entitled to get it.
There are two judgments, honorable court.
same lines.
Paragraph 14, my lord.
No. These are not this case. No. These are motor accidents tribunal, not these cases. There is a judgment. Ask Mr. B. Chaudhary, the APDCL counsel. He was appearing and there is another counsel who was appearing for the petition, I don't remember. This is a case where there was a order of saying that a coordinate bench has stated that if it is a case of contributory negligence, one is not entitled to. I said no, it can't be for so because of the fact that Section 5 only says about negligence. And when it is a welfare statute, and this statute is only brought in for the purpose of paying an ex gratia to these people for immediate relief. So under such circumstances, this should not come into the way and they are entitled to. And they have not said that the entire liability, it has to be sole liability negligence. The sole liability is not there. That is why I said that. Right. So that is the judgment you get it. You have it? J.K. Usami.
Yes,
You have that?
At present, I have not. I can bring it.
So that is the case. I told you last time when the matter came up. You have got something else. This is motor accidents claiming.
Yes.
Pursuant to the order dated 4/11/2024, the matter has again, it is seen that the affidavit has been filed by the respondent number 4, wherein it has been mentioned, whereby a fresh electrical accident report has been incorporated, have been brought on record, dated 25/9/2024. Mr. J.K. Goswami submits that he would like to go through appearing on behalf of the APDCL, submits that he would like to take instructions in that regard. List this matter again on 19th of December 2024. You get that judgment.
39.
Yes, what is this?
My lord, this is against the Bakijai notice, my lord. That is, my lord. Page 176, my lord.
Yes, what do you say?
My lord, he was a defaulter. So initially the rules provide in case of default, the Bakijai proceedings will be initiated. The DC has initiated the Bakijai proceedings on the basis of our report. And he claims that he could not pay the kissed amount because it was non-operational. However, it was not due to our fault. It was his projected case is his EC was not extended by a authority called SIA, State Environment Impact Assessment. That is his case, my lord. Now he says that Bakijai proceeding which will be initiated is bad because he could not pay the kissed amount due to non-operation, which is not again our fault.
That cannot be the basis. The question is whether jurisdiction is there or not. When there is a failure to make the payment, then obviously the jurisdiction is there.
My lord.
The question whether he could not pay for the Bakijai proceedings to look into it.
My lord, yes.
Whether
Bakijai
if he
officer
could
will look.
not pay, he has to therefore take up with the DC or
Yes.
whoever it is that kindly don't initiate all these things.
Yes, my lord.
But how can he challenge the Bakijai proceedings?
Exactly, my lord.
Yes, submit, my lord.
Yes.
My lord, what happens in this case?
You file your affidavit.
Will file, my lord.
File your affidavit. But there is no interim order extended on 19/7.
No payment.
Mr. D. Gogoi appearing on behalf of the Forest Department. Forest
Forest, my lord.
is that he would, the affidavit would be filed on behalf of the Forest Department in 3 weeks. 22nd of January 2024. In the meantime, the affidavit be filed by 7th of January 2025.
43.
Yes, Mr. Talukdar.
In fact, this petition is for non-acquisition of my land used by the respondent number 2, Water Resource Department. While they have used my land and they are now denying, in spite of the fact that revenue authorities has been repeatedly affirmed that my
Now,
land has
whose
been
land
used.
it is?
That's it.
Land is with whom? Land is with whom?
Which in their possession now, they have used it for constructing the dike at Zapada Gaon, ward of Dibrugarh town.
Then?
Then Lordship, it was originally it was a 50 something when it was constructed. During upgradation of that dike, Lordship, 2013 or about, they have used my land, and they say now that they have paid. They have paid. What land has not been acquisition? 346 initially they had acquisition. Subsequently they used.
Lordship, in this matter, we have written a complaint to the CBI, Lordship, and it has.
You have given a?
CID.
CID, they have filed
Then?
one FIR. Lordship.
And it is under investigation, Lordship.
So, it is his land.
Yes,
There is sale deed.
pardon, Lordship.
Is there a sale deed?
According to us, the dike has never changed, Lordship. Dike has never changed its position, Lordship. It is in its original position from 51. And the petitioner have bought the land in 71. So Lordship, if it was, our dike is from 51. So a government land cannot be sold, Lordship, in the year 71.
Oh, that is why. Chalo, we'll have this. All affidavits are, pleadings are complete.
Yes, sir.
Yes,
Chalo. Taking into account that the pleadings are complete, please this matter on 6th of February 2025, an attempt shall be made to dispose of the petition on that date. So therefore, the question is to be finally decided here as to whether there could have been an acquisition of title in respect to the land when the land actually belonged to the government.
See, one more thing, if I am permitted to submit, Lordship. What happens,
No, we'll hear you later on.
Lordship, 44.
Yes, Mr. Deori. What are you
The matter
asking?
may be disposed of. This is order passed on 12/12/2023.
RTI,
RTI, Your Lordship, it may be disposed of there.
you got the order.
Yes, the order has been passed, Your Lordship.
And to get it, is
Inquiry
conduct
has
an
been
inquiry about the availability of different kind of data, including those documents, copy of which are sought by the petitioner, and furnish a report to the, on the findings thereof. The report will furnish to this commission within a period of 15 days from here. Then what happened?
Nothing, Your Lordship. This day only.
Are you not appearing before them?
I had appeared, Your Lordship.
And what is happening now?
I do not know. This was provided to me by the council, Your Lordship.
No, it won't. You are to go there. You are the appellant.
Yes, Your Lordship.
Then you have to get an information what has happened thereafter. Is the TDFD submits that as there is already a proceedings before the Assam State Information Commission, he would like to inquire as to what has further transpired therein. List this matter again on 7th of February 2025.
45.
Yeah, please, Your Lordship.
Ah.
Respondent number 2, district administration filed an affidavit in opposition, and I'm petitioner also filed an reply on day before yesterday. Lordship.
Then
This is settlement of land, Lordship.
for the land.
Land.
Huh?
VGR land, Lordship. Kaziranga Mode.
VGR land.
Lordship.
How can you get settlement?
75 already settlement done, 1984-85, Lordship.
Now what are they doing?
Now, we are deprived this settlement of land, Lordship. Various communication done, Lordship.
So you want the de-reservation of the VGR land?
Land, Lordship.
So then the government has to de-reserve. Where is the land?
Land Kaziranga land.
Forest?
No. This is a government land, Lordship.
Yes, madam. Any instruction?
75 already settled. 1984-85. Erosion affected people, Lordship. ST plain, Lordship.
Please this matter again on 11th of December 2024. Full stop. On which date Ms. M. Bormon, appearing on behalf of the district administration, shall take an updated instruction of the matter.
46.
What is this?
My Lordship.
What is this? Oh, madam, there was a big problem in this matter when the matter came up earlier, na, before me. I remember. There was something not done.
There is not proper proceeding.
Ah.
But my Lordship, may I pray any fruitful order, fruitful suggestion from Honorable Court, my Lordship?
Let me think about it. Not today, it's not a time. We'll do one thing. Let us take up this matter. No, I will take up the matter at 2 o'clock tomorrow. On Friday at 2 o'clock, I'll take it up. Then I can get some time. Today I'm in a rush. There are many matters, na?
I, I,
Mr. Gogoi, kindly think about it. You are such a knowledgeable counsel.
Yes, sir.
Think about it. Come up with a suggestion. What can be done to the child? Who are you?
Victim. Victim.
Victim means?
He was.
Respondent number 7.
Mother.
Father, district father.
You want the child with you. You want the child with them. So you want the child with them. It's okay. But the procedure has not been properly done. That is it. What can be done? Because you see, we are concerned about the child. Something good for the child should happen. Think about it. Come up at 2 o'clock on Friday. This is the matter on Friday, 29/11/2024 at 2 p.m. This will
47.
Have instruction to withdraw this request and
Fantastic.
liberty to approach the respondent authority.
Why? What is this liberty business? Oh, has been blacklisted from all the tender of air for a period of 5 years from issuance of the Iman. In addition to that, Iman, taking into account the fact that petition has approached almost 1 year, 5 months, this court is not in. Yes, you were blacklisted, na? Without providing the due opportunity. Now what happened? You want to withdraw?
Yeah. Liberty to approach the respondent.
Approach them. Why?
As per instruction of my client, I submitted.
Huh?
As per instruction of my client.
You withdraw. Why should I say anything? The counsel appearing on behalf of the petitioner, Mr. R.K. Moore, submits that he has instructions to withdraw the instant writ petition inasmuch as the petitioner he submits that the petitioner would like to submit a representation before the authorities concerned. Taking into account the above, the instant writ petition stands closed on withdrawal. The petitioner is at liberty to submit such representation if so advised.
Supplementary item 68.
Okay. Yes, Mr. Vishwas, what is
My
this
lord,
matter?
They have filed an affidavit as per your direction. They have mentioned the breadth, not length. Length is a
Oh, that one.
very tactfully avoided it, my lord, length.
Hmm?
My lord,
So
it-
they admit
They
that your
admit.
land has been taken.
They admit. Page 45, my lord, kindly.
Page
45,
2011. 2011. Let us.
Para 4, last portion, my lord, they admit.
District Commissioner,
map, but
as per the report dated so and so, two Pattadas, Alamuddin and so were mentioned in Dag number Iman. And 3 Pattadas, Alamuddin, and revert on the circle officer. Take of that. Yes, what is your, what, Mr. Biswas, what does he say? What do they say? It's very difficult for this court to understand.
Earlier they denied that they.
I have asked them a very pinpointed, simple question. While making the road, you have encroached upon the land of the petitioner. What is the difficulty of the circle officer or the district commissioner to make it a clear statement to that effect as to whether the land of the petitioner has been encroached by the road? This can be seen from the map, and from the map it can very well be seen as to whether the road falls now there or not. Why is not a direct answer? Madam, kindly see my order of 11/11/2024. So Vishwas, do you have the order? 11/11.
Not collected.
See, madam, what I have written. Taking into account the above, this court directs the District Commissioner Borpeta to file an affidavit explaining the contradictory nature of reports being submitted by the revenue authorities under his jurisdiction, as well as also state in clear terms as to whether upon field verification, any land of the petitioner has been encroached for making a construction of any road. Simple question, simple answer. What is wrong with your deputy commissioner? Who is he?
Yes,
I think we should.
Circle officer. Additional deputy commissioner.
We take the advantage also in speaking in vernacular language by asking him, the deputy commissioner, to be present in the court and explaining him in Assamese or Hindi what this court meant if he doesn't understand the simple English language. What do you say?
Kindly fix the matter on,
No, I don't understand. What does he write? See,
I've seen lordship.
as reported by the circle officer Hotebari so and so, as the question whether any land of the petitioner had been enclosed for construction of any road, based upon physical area, it was found that a concerned road which is marked as a dotted line on the map falls on dark number 144 of so and so, though the specification of the dotted line is not given in the map. But during physical verification and local inquiry, it was observed that there was small road on the dotted line area prior to construction of the road undertaken by the so and so. And also it has been found on the physical verification along the western side of the existing road in dark number so and so. Excavation of land with average approximate width of 15 feet have been done in road to raise the height of the existing road. Is that an answer? Mr. Vishwa, is this an answer to a simple question? He also knows what is a simple question. The records of the court case shows it means if I keep on writing like this, it will be either the fact that I am not being able to convey to you, or you are not being able to convey to the district commissioner, or the district commissioner does not understand, or for good reasons he is not mentioned. Answer has to be simple. There is no doubt that dark number 14-4
Yes.
of 144 or patta number 4 belongs to them. Simple question. So under such circumstances, whether the road falls in dark number 4 of dark number 144 or patta number 4, that is the answer. I hope you explain. Get your instructions. The instructions so sought for in the order dated 11/11/2024, though explained, though mentioned, though answered, though mentioned, though incorporated in the affidavit filed by the respondent number 3 on 20/11/2024, but the same does not appear to be clear. Because this court reiterates that the query sought for by this court is as to whether any part of the land belonging to the petitioner have been brought within the ambit of the road so constructed. The Deputy Commissioner shall look into the same and provide necessary instructions by the next date. List the matter again on how much time? Again on 11th of December 2020.
59.
May I please, your lordship? The last occasion, lordship directed them to make clear their stand on record.
It is stay to the impugned notice and have neither given any instruction. Yes, what is your instruction?
Lordship, yet to receive instruction, Lordship.
Huh?
Yet to receive the instruction, Lordship.
First. It is seen that this court have on various occasions sought for instructions from the respondent authority, the respondent, which are the district administration as well as the revenue department. However, there is no instructions so placed before this court. Under such circumstances, this court issues rule in the instant, admits the instant writ petition and fixes this matter for hearing in its usual course. The interim order so passed earlier shall continue till the disposal of the writ petition.
Oh,
For orders, item 48.
My lord, I am to file a substitution petition against R3 in the month of January. In the meantime, I have collected with great difficulty.
Who died?
No, I have not filed. I am to file.
Who died?
Respondent 3, Horkanda Deka.
Respondent died.
Who was the option person?
Okay. The counsel appearing on behalf of the petitioner submits that some time is required for obtaining certain steps to establish the matter after 6 weeks.
6 weeks.
59 and 50.
Please, Your Honor. Sincere apologies for not being there in person.
Yes, Mr. Counsel. Yes. You took time on 18/4/2024 for asking for the same thing?
But at that time, the instruction is that the legal representative of is not found. It is village Aurora. Who purchased the auction?
Is there an interim order?
Interim order is
Interim order vacate.
against revenue board of revenue. There is interim order.
No, interim order will let us vacate it. No, I got file today. No, I got you. The matter, it is seen from the records. So I got to ne? No, 2031 to do.
Interim order may not be vacated. Lord.
No, no.
It is against the board.
Yeah, I got to 48. No, Mr. Counsel, one has to be strict. You have taken time for filing an application for substitution.
Lordship,
Now you want a substitution, I should continue a interim order against a dead person. It is seen from records.
Board of revenue. Case is against the board of revenue. He is a private. He was the auction purchaser.
It is seen from the records that on 2/2/2021, the counsel appearing on behalf of the petitioner sought for time for filing an appropriate application for substitution of the legal representatives of the respondent number 3 who have stated to have expired during the pendency of the writ petition. Full stop. 3 years, more than 3.5 years have already passed, but no such steps have been taken. Full stop. Under such circumstances, for the ends of justice, the matter stands, this court grants an additional opportunity to file the application within 10 days from today. Full stop. This court, the counsel appearing on behalf of the petitioner submits that the interim order be continued in the past on 28/3/2016 be continued. Full stop. It is seen that the said interim order have not been continued since 18/8/2017. Full stop. In addition to that, continuing and directing a passing of an interim order against the dead person would not be in the ends of justice. Accordingly, matters stands adjourned.
We could not find a legal representative. That was our difficulty. Now, after long.
Mr. Counsel, today I'm in a very good mood. Otherwise, I would have dismissed your petition on that. No date. Yes, what is this?
Please, Your Honor. So this is the matter to do with the PF dues for a tea garden called Bhuvan Valley Tea Estate.
Oh, that inventory list.
That's correct. Inventory has come, Your Honor.
Huh?
We have already filed our additional affidavit as per your lordship direction, my lord.
You have filed it, na? Okay. So this matter should come up for admission
For
then?
admission hearing, my lord.
Huh?
Let them
The-
for admission hearing.
List the matter for admission hearing. This
One
court have duly
one
taken-
submission, Your Honor. The receiver's affidavit is not on record.
taken note of the affidavit, taken note of the office note dated 29/7/2000, the office note dated 29/7/2024 and 8/11/2024. So taking into account the above, let this matter be listed for admission on after vacation? Admission.
Your Honor, no difficulty with that. Just one small submission. The receiver's affidavit is not on record because the receiver was impleaded at a later date. So I'm just putting it for your Honor's information.
January 2024, 5. To stop the, in the meantime, the affidavit.
Please.
Receiver is you? 7. In the meantime, the respondent number 7 is given a final opportunity to file their affidavit on or before 2/01/2025.
Deeply obliged, Your Honor.
Their appearance only this year, September.
So what?
Want to come. Let's ask you when you want the final opportunity.
Final opportunity. Last opportunity.
Publish to your lord.
Will I
51.
failure to file the affidavit, this court shall construe. Should I?
May I please, lord? I am not pressing this matter as instructed by the parties.
Huh?
Parties has already settled the matter.
Amicably settled. Mr. M. Islam, the learned counsel appearing on behalf of the petitioner submits that the matter has been amicably settled and as such he would not like to press the instant writ petition. So accordingly, the instant writ petition stands closed. The interim order passed earlier stands vacated.
52.
None appears on behalf of the petitioner on call. It is further seen that no steps have been taken as against the respondent number 7. As would appear from the law order of the Lozima Court dated 2011-2024. Accordingly, lists this court. Accordingly, list this matter again on 8th of January 2024. In the column, and list this matter. If no steps is taken in the meantime,
53,
Respondent number 5 and 6 took time earlier occasion to file affidavit.
service complete.
Service is complete.
As per as served upon the result has been complete, but no one has appeared for respondent number 7. So, service complete.
They took
Huh?
time earlier occasion to file affidavit.
Service complete.
Service complete.
So, service being complete.
For respondent number 5 and 6, Lordship.
Okay, take it. Service being complete, list this matter for admission 5th of February 2024. 5. The interim order passed earlier shall continue till then. The respondents in the meantime would be at liberty to file their reply.
54,
Service not complete, list the matter after completion of service.
55,
Service is complete. 55, service is complete. Is the matter for admission after 4 weeks.
56,
You have not submitted the amended cost title.
That is 55.
56.
I'm. where for the-
55, service is complete, list the matter after admission. For admission.
56, I have to amend the writ petition as a whole, my lord. There are
What?
some formal defects in the writ petition.
You want to withdraw?
I amend the writ petition, liberty for that, my lord. Not the amending the cost title itself will not serve the purpose. No, there's a history of this matter, my lord. There was a previous council.
No. The question is, do you amend the petition or whatever may be?
Yes,
There
I
is
have
an
to file-
order passed by this court to file a memo. Parties, you don't want to file it.
Seek
No,
liberty
naam to diyo,
to-
kadi diyo.
I seek
File diyo,
liberty
file
to file a IA
Page
for
50,
amendment.
56 to diyo.
So there is a formal defect, my lord, in the writ petition filed by the previous council.
So this court, by an order dated IAS नहीं था by an order dated (24/7, 2023) directed, observed that the respondent number 2 be impleaded in the presence of the learned Register General, and the counsel for the petitioner was directed to provide the amended cause title. However, it is seen that since then, till date, no such amended cause title have been filed. Under such circumstances, this court modifies the order. Now, this court dismisses the instant proceedings insofar as the respondent number, so far as the complainant in CP case number 24/2021.
That order, my lord,
The maintainability of the instant petition, hence, this was list this matter after 4 weeks.
So that order, my lord, there's a
Dismiss it. No, you have not done
separate
it.
set of counsel, my lord, there's a separate set of counsel.
So what?
But
You
the
appeared
counsel has
long time
abruptly
back.
withdrawn, my lord, I can produce. the
No,
mail.
nothing doing. This is not how you manage it. You have been asked to file a memo of parties. Is this the manner you have appeared?
It's the fault of the earlier counsel. my
Who is
lord.
the earlier counsel?
She's on record, she's on.
Who is he?
record. One Miss S. Chakrabarti was there, my lord.
Then
And my lord, she has suddenly withdrawn from the case, my lord, by sending an email to the bank. My lord. This is the manner.
where is your wakalatnama?
My wakalatnama has been filed. my lord. I'm
No,
on record.
wakalatnama
My
confirm.
name is there. for this.
When did you file?
But I have filed on the last day. Just shortly.
When?
The order was passed in 2023. In fact, the writ
So,
petition,
24/11, 10.
the writ petition itself has to be amended, my lord. I'll take the necessary
No,
steps.
no, if you don't take steps as per the orders passed by this court, then obviously this is a case of dismissal.
There is a default, my lord, on the part of the previous counsel.
Then-
For that, the client may not be.
So what? We're not bothering. Go to the division bench. Better off. This
But,
type of matters should happen, go to the
But
division.
that liberty
You're a
may be
big
given to
company,
amend.
Indian Overseas Bank.
Liberty may be given to amend the writ petition.
What?
That.
Mr. Ganguly,
Because I appreciate.
have
what
you
is following.
changed your name from A. Ganguly onwards to Aya, or should I know that you are no longer a person who doesn't know head or tail about the basic civil law? You file an application that I give you a liberty to file an amendment without filing an application for amendment.
That the order.
Do you want this court to be laughed by people? That I give you an amendment, okay, the petitioner is allowed to amend the petition without an application.
The complainant in that case, my lord, the CP case, my lord, they have to be brought on record. My lord. That is the.
That the permission was already given, the order was
And
given.
it was not done. my lord. That is the default.
That is what I'm saying. I'm striking off the name of the year.
Then my
striking
IA
of the
becomes
name.
Any IA that I filed, my lord, becomes non-maintainable in view of your lordship's order, my lord. Today's order.
Therefore, I'm dismissing it. This is the provision how you act as per the CPC. Don't you dismiss it insofar as that person is concerned?
Be able to implead the informant. That will be the difficulty, the complainant in the case.
Fantastic. That is a good thing, which you'll learn next time. Shouldn't happen.
That is the default.
Want to amend this petition and saying that this court should permit you to amend without an amendment application. Is it heard
I'll
of?
file that amendment, my lord, but this order will come in my way, my lord, for this order of today's lordship's today's order will come in my way because. if I-
Absolutely. When the court has given you a permission to make in a memo of parties, you don't do it
Sir,
so
There
obviously.
is a default on the part of the council, my lord. For
Hello,
that,
we impose a cost of 10,000 rupees then.
that may be done. No.
So it is seen from the records that this court, by an order dated 24/7/2023, had directed the respondent, petitioner, to file a fresh memo of parties. As on date, no such fresh memo of parties have been filed. The learned counsel appearing on behalf of the petitioner seeks for another opportunity. Full stop. Full stop. Taking into account that the order passed by this court have not been complied with, this court imposes a cost of rupees 25,000 upon the petitioner to be deposited before the registry of this court within 7 days from today. Full stop. Along with that, the petitioner is to file the fresh memo of parties. Full stop. If it is not done so, the matter be again placed before this court.
2 weeks. 2 weeks to deposit. 2 weeks to deposit this amount. 2 weeks.
Well, how
So
much
7
did they say?
Lordship has said 7 days.
Okay, 2 weeks.
Deeply.
7 to 60.
What are these? I can't take up these matters. I've appeared for this company.
I am appearing on behalf of respondents 6, 7, and 8. Our name has not been shown, my lord.
I won't list the matter. It is all our mother cut.
Yes, ma'am.
List the matter before any other bench.
Obliged.
There is an interim order in that.
Lordship. In
Item number?
in WBC number, item number 62, WCBC number 560, there's a mistake on my part. That here I was supposed to file an.
Item number 61, 62,
61 and 60.
along with 71.
Yes, Lord.
You have not filed a fresh memo
Yes,
parties.
Lordship, that, but due to mistake.
Fellow, we dismiss
file
it
it.
against that person concerned. Yeah, one fellow. We dismiss against that person concerned, the petition.
I'll file it by tomorrow.
I'll pay 25,000 cost, whichever it is.
Lordship, one another thing, Lordship, in item number 562. The order was passed on 29/23. And undertaking was given by the respondent number 4, that is the petitioner in item number 61.
Where the order?
That is at 29/20/23.
Into item 62 kuntu hai. 62 dio. There's no order passed.
29/20/23. Lordship, item 3993.
Ekon ki aaye kon jo dilse apna.
Item number 62. WBC 3993.
Affidavit, where is the order passed for filing memo parties?
That is Lordship in WPC number 560/2024. That is item number
50
560.
560 page.
Is
Which order?
on the last occasion, Lordship has passed an order. There was an IA filed by the respondents that to implead him as a party respondent. So I was directed to file a fresh memo that I have by mistake that I have failed.
So it was done on 11/9.
Yes.
11/9, 2024. Okay. The council appearing on behalf of the petitioner submits that 1 week time may be given for submitting the fresh memo of parties. So this court runs a week's time to file the fresh memo of parties on or before 6th of December 2024.
Item number 62, Lordship. Item number 62. I'm pointing out on order, Lordship. What they are doing now. They have given an undertaking, Lordship, on 29/2023, that there will be no construction work there. But now they have been undertaking the construction work there in violation of that order undertaking.
There's a violation, file a year.
Lordship,
Contempt.
that's why, Lordship, I am praying that this matter may kindly be segregated, Lordship.
Which one?
Item number 62.
62 is different from 61.
Yes.
Why?
62 is against the, some notices were passed by, issued by the GMC. They did not take any action against the respondent number 4, that is the petitioner in item number 61. Then they approached this honorable court for staying that notice.
You have filed an IA.
Yes, sir.
For what?
For stay.
Stay
That
of
was,
what?
that was not considered, not for stay, for taking coercive action of it against the, GMC and GMT.
Whose petition? Who is the petitioner therein? 62, who is the petitioner?
Pradeep Hazarika, Lordship. The
Who is the
respondent
petitioner? You are the petitioner.
Yes, sir.
So you want some coercive action be taken against them.
Against them by GMC and GMT.
But wouldn't that amount to final adjudication?
Lordship.
Wouldn't that amount to final adjudication?
Yes.
So can we do it by an interim order?
By interim order, a final adjudication. No, I am praying that if the matter is not segregated, they have been delaying my regards by filing this petition.
So list these matters again on 11th of December.
Both the matters. Also.
63.
Yes, what is this?
Please, Your Lordship, in earlier occasion, the honorable court is directed to obtain instructions regarding the country liquor. But the applicant is out of station, that's why we are unable to obtain instructions.
Huh?
Only allow some time to obtain instructions.
You don't have a case.
We have filed an I application for.
What have you done against the country liquor shop?
But the applicant is out of station.
Huh?
We are unable to obtain instruction, my lordship.
So they were very positive earlier. You're fighting tooth and nail. When I put a question, what action have you taken against the country liquor shop? Then you are not able to get your instructions. What is it? Huh?
As per my instruction, it's in the same building, Your Lordship. It's in the same building.
Same building. You have no problem. Are you at the behest of the country liquor shop?
Actually, the.
No, I'm asking you, are you at the behest of the country liquor shop? Because of the country liquor shop, because of the IMFL shop coming in, so you are not there. Must be something like that. Huh?
I mean, the.
Let us have a CID inquiry and see the antecedents of these persons. Because this keeps on happening. Huh? And when there was already a report being given then, CID inquiry would be better. Now you're running.
Yeah.
Yeah.
So we allow your reputation then. Dismiss their application. Let it come up next week. Yeah. This matter again. Week.
465.
And let's this matter again on 13th of December.
May I please, Your Lord. My lord, I am for item number 65, Lord.
Why the first appeal? It's against the first appeal.
Here, the grievance of the petitioner is that their land records have not been corrected, demarcation has not been done, and identification has not been done. Well, we submitted before your lordship on there was a letter on 15/6/2022. We said that the process has been initiated, and now.
What are these cases? Union of India.
Union of India, they said that the railways.
Who is
they said-
paying for Union of India? Mr. Sharma, you are paying for Union of India.
Lordship.
What is your case?
I-177.
Huh?
Their grievance is that
65, I think.
pursuant to land acquisition cases, land has been given to them, but the land has not been demarcated and the land record has not been corrected. Therefore, some encroachment and all these problems they are suffering. That is what they pray, that land should be demarcated and the record should be corrected. My instruction is that I have placed before lordship. The land has been now, it has been, the record has been updated. Map is there, and they have two DAGs, DAG number 44 and 967. Map has been, the Jamabandi has been updated. Press map has been placed before your lordship. And kindly similar.
You have acquired 63 bigas.
Lot.
And how much does these DAGs of the railways contain?
Well, their land as per this report, serial number 3, kindly see. At present, the acquired land for Brahmaputra Bridge construction is corrected in DAG number 44 and DAG number 967. which contains an area of land measuring 71 biga, 3 kotha 11 lacha. So these are the two darks. And
Understood, but for railway, you have only acquired 63.
63, 60.
Then how does the land becomes more?
No, in that particular duct, some other, the 10 biga land, malad, kindly come to serial number 4, malad. At present, duct number 40, 41, 42, 43 is private land covered by duct number so and so, wherein a part of land measuring 10 biga covered by duct number 40 is in absolute possession of one Raju Prasad Sharma. The entire land of duct number 41 is in possession of NF Railway. Part of duct number 42, 43 is under occupation of public. So, malad, the present cadastral map we have given. Malad,
No, but it is KP Patta number 567. You see, dark number 40, 41, 42, 43 is in KP Patta number 567,
567.
wherein the railway is in possession.
Malad, this 63 biga, what I have seen, malad. In these two LA cases, 63 biga has been acquired, but apart from that, railway has some other land.
No. See, if you see 4,
Logic.
dark number 40, 41, 42, 43
Logic.
is a private land covered by KP Patta number 567,
Yes, sir.
wherein a part of land measuring 10 biga covered by dark number 40. 10 biga of dark number 40 is in absolute possession of so and so. That means
Raju Prasad.
it is a Patta number 567.
Patta number 567.
Rest of the land of dark number 40 and entire land of dark number 41 is in possession of NF Railway. Part of dark number 42 is under the property of public. So under such circumstances, these are all Patta lands.
Patta lands.
Now, when you issue a land to the railway, you issue a dag or patta. You don't issue a patta.
But the original LA case land, that is under duct number 44 and 967. 40, 41, 42 and 43, those are different land. Now a dispute has come up, the railway is alleging that some construction is going on over that particular land, that is our land, so you demarcate the land. But the LA case, which two LA cases were there, malad, in 59, LA case number 17 of 59 and LA case number, that is the main case. There, malad, we acquired 63 biga and that particular land is available in duct number 44 and 967. Not in the other ducts.
But that is 71 bigas.
That is totally 71 biga. The acquired land for railway is 63 biga.
Hello, we'll take it up later on. Very difficult to understand. Have these.
But Lordship has directed us to file an affidavit. I have got the instruction. Kindly give me one.
The
1 or 2
dean
days
submits
time.
that he has already received the instructions and he would like to bring on record by filing an affidavit to stop this matter again on 27th of January 2025. In the meantime, the affidavit be filed. Then 66. Very good. 27th of January. 66, no?
Please, your lordship. My lord, this IA is filed by the petitioner's lordship for passing an interim order, lordship directing the authority to release the Jirat compensation at least for, so that we can take shelter somewhere there.
So the amount has been finalized. And now he is entitled to the amount.
That has come because the requiring agency is not NSAI. They have wrongly implemented the NSAI for who is a constructing agency. Now it has come to know from the Kala, it is the NSAI DCL. He has to implement now NSAI DCL.
Oh, pursuant to the order passed by this court on 18/11/2024, it has been informed that the NHIDCL is the appropriate authority who, for whom the land has been acquired. The learned counsel appearing on behalf of the petitioner shall take appropriate steps in that regard. List the matter after 3 weeks.
Correction.
7,
Sir, I was directed to file my lord amended quantitative life file on 25th Jan, my lord. My lord, regarding my lord, heavy settlement, my lord, it may come, my lord, for admission.
Okay. Now it has been already removed. So list the matter for, yeah, admission, na?
Admission.
List the matter for admission after 3 weeks.
Obliged, Lordship.